Yeah, as soon as she comes back in, I'll have her call downstairs. Calling parties on Walker is Dominic.
Ready.
Case number 2159570, the people of the state of Michigan versus Dominic Jonte Walker. The defendant is charged with count 1, stolen property, receiving and concealing $20,000 or more. Count 2, police officer fleeing third-degree vehicle code. Count 3, police officer assaulting, resisting, obstructing. Habitual offender, second offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Is that? That's Mr. Slusky's case.
Mr. Slusky, are you here?
I'm gonna.
Oh, okay.
Good morning, Your Honor. Rima Fufi on behalf of the people standing in for APA Jacob Slusky.
Thank you.
Good morning, Your Honor. Sanford Schulman, P43230, appearing on behalf of Dominique Walker, who's participating at the Wayne County Jail by way of video conferencing with our consent and permission.
Okay. Please state your name.
Dominique Walker.
Thank you. Counsel, what's your pleasure?
Your Honor, this court adjourned our probable cause conference for 1 week to allow us an opportunity to confer. I met with Mr. Walker at the Wayne County Jail in person. I reviewed the discovery with him. I inquired as to whether he wishes to proceed by way of holding or waiving the preliminary exam, and whether by video or in person if it's going to be a hold. He's informed me that he wishes to demand an exam in person. So we'd ask for a firm date.
Okay, would you like to select a date within the next 7 to 14 days?
I'll leave it to the people, obviously.
I ain't say it gotta be in person. We can do it via Zoom.
Okay, wait, I'm sorry. Let me back up 1 second. So it's a little difficult leaving it to the people because Madam Prosecutor is standing in for Mr.
Okay.
And it's a little difficult for you to leave it to us because
Okay.
we're spilling over at the brim. So we don't have any dates available for exams until like December. However, because your client is in custody, that's why I'm suggesting that you select a date, and we're going to elbow out other matters that are non-custodial.
Okay, that's fine. But since we're not calling any witnesses, I didn't know that's how you want to proceed. But he's informed me just now that he's amenable to doing it by Zoom. So
Okay.
I have several matters next week, but Thursday, August 12th, if that's an available date, would be fine, or Friday the 13th. Those are the best for next week.
Is Mr. Cook going to be handling Mr. Slusky's exams?
Yes.
Okay, so we don't really have Mr. Cook here. We have Ms. Yafufi, who's gracious enough to stand in. So we're going to set a date and hopefully we can shoot a message to Mr. Cook.
I'm gonna do that right now.
Thank you. And let me back up. A Zoom exam and an in-person exam, back when the pandemic first began, a Zoom exam gave a closer date. Now there's no difference in terms of timing. So if your pleasure is to have a Zoom exam for some other personal reasons, then that's fine. I just want to be clear as to the reason why you're asking for a Zoom exam.
I just proposed that he could, I thought it could be both available to him, and he's just elected to do it by way of Zoom. That way, maybe he wouldn't have to be transported to the court. I'm fine with it. I don't think there's going to be any difference in terms of the effectiveness of it. So he's just indicated that Zoom is fine, and I'm okay with that as well.
Okay, so Mr. Walker, do you understand you have a right to a live in-person examination?
Yes.
You understand that what's being proposed here is a Zoom exam wherein you're going to be Zooming in just as you are right now. Your attorney is going to be Zooming in. The prosecutor and any respective witnesses would also be Zooming in the Zoom galleries where you would see them. Do you understand that?
Yes.
And you would not be sitting shoulder to shoulder, so to say, with your attorney such that you can lean over and communicate. Do you understand that?
Yes, we can do it in person. It really doesn't matter.
I'm gonna put you in a breakout room, the two of you. Let me know what you'd like. It's not the decision for me to make, so.
Well, I think he's just saying it's either way is fine. So, Ron, if we can set it for Zoom, I'm amenable to that too. So,
Okay, still need to ask these questions. I'm so sorry. I don't mean to belabor the situation, but okay, what I was trying to ask is that, do you understand in the event that you need to communicate with your attorney, you would need to get the court's attention, and I would put you in what's called a breakout room. Do you understand that, sir?
Yes,
Okay, the burden on the prosecutor would still be the same, but the communication is just going to be in a different manner if you need to talk to your attorney. Do you understand that?
yes,
$1 million question here is, do you waive, do you give up your right to an in-person exam so that you would have a Zoom exam instead? I need an auto.
never mind. I'd rather have an in-person exam.
Okay, in-person exam. What were the 2 dates that you suggested, Mr. Schulman?
Thursday the 12th, Friday the 13th.
Okay, Friday the 13th sounds ominous. So let's say Thursday the 12th at 10 a.m.
Very good.
In-person examination.
Very good. Yes.
Thank
Thank you
you.
for your patience, Judge.
Oh, no worries. We'll see you on Thursday, Mr. Schulman.
Yeah, very good.
Coffee parties on Alderman. Case number 2155276, the people of the state of Michigan versus Larry Alderman. The defendant is charged with counts 1 and 2, weapons carrying concealed, count 3 and 4, weapons, firearms, possession by felon, count 5, weapons, felony, firearms, second offense notice, count 6, weapons, felony, firearms, second offense notice, count 7, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams, habitual offender, third offense notice. Judge, this is scheduled for a competency hearing.
Thank you. Before we begin, let me just say good morning and everyone new and old to Zoom court. If you're new to Zoom or you've been here before, welcome. There's a few expectations that I have. Number one, I need the prosecutor to put their appearance on first. If you don't hear a prosecutor put their appearance on, please don't provide your appearance and your client's appearance. We need both. So we will have to pass if we don't have opposing counsel there. And it's nothing personal, but we do need to have prosecution and defense on any given case. Then I need defense counsel to put their name on. And in the event that your client is there, I don't know what your client looks like or if they are there or if they're in custody or out. I need you to supply that information. And if they're there, they need to put their own name on the record. If they are not there, then please let me know if you're requesting to waive their presence. That's going to be the launching pad for every matter that's called. And then we'll jump into the substantive nature of what we're doing. If there's an emotion or special attention or concern on a case, please make sure you're in communication with opposing counsel prior to the case being called. Shoot them a text, hit them in chat in the Zoom gallery so that we don't have to pause the proceedings. That would be great. Also, for the defendants that are here, my expectation is that you familiarize yourself with your device to the extent that you know how to mute yourself. My expectation is that all audio would be muted. All microphones are muted unless you're actually speaking. It's a little microphone, tap on it in order to mute yourself. Also, my expectation is that you will have your camera rolling. So if you're not familiar with your device, take a moment right now, figure it out. There's a little camera that you tap on. I will need your video rolling when you're speaking. I also have an expectation that you're going to be properly clothed. In fact, wearing clothes. Please wear clothes. Do not come to the Zoom court without clothes on. I know that's fairly obvious, but every day, inevitably, every day, there's someone who comes to Zoom court without clothes. Also, if you're going to handle any personal business like going to the bathroom, or anything that you wouldn't typically do inside of a courtroom. Here's the beauty of Zoom. You can just tap on your video and it goes off, and we have no idea what you're actually doing. Just make sure that your audio is also off. Also, please refrain from the use of any profanity. That would be great too. With that being said, I think we're gonna have a really smooth morning, Ms. Youngby. Okay, appearances on Alderman, please.
Good morning, Your Honor. Rima Yacoub on behalf of the people.
Good morning, Your Honor. Judith Grady on behalf of Larry Alderman. He's on Zoom, Your Honor, and we have no objection to having this hearing on Zoom.
Thank you. Mr. Alderman, please, your video, if you would, and please state your name.
Larry Reno, Alderman Jr.
Thank you. Okay, Madam Defense, what's your pleasure? Good morning to you. What's your pleasure today?
Good morning, Judge. Hey, we had the opportunity to review the evaluation for competency, and they
Yes.
find my client competent to stand trial. We have no objection. We actually stipulate to this report.
Prosecution?
The people stipulate as well, Your Honor.
Okay, given that stipulation, the court will accept that stipulation and find the defendant competent to stand trial. That being said, and that business out of the way, what's your pleasure?
Your Honor, we need an in-person exam date, please.
Okay, are there concerns regarding bond that might affect the timing of when this exam is set?
None from the people, Your Honor.
He's out of custody, Your Honor. I believe I asked to continue the bond.
Okay, just bear with us and don't get too shocked by the date. Please, I'm also assuming that defense attorneys are having a separate conversation with their respective clients about how the pandemic has actually affected the court system and the timing of everything. So please don't be shocked by the date you get for this non-custodial demand for exam.
Judge, January 6th at 9:30.
Madam Defense?
That's great, Judge. That's a fine date. Thank you.
What time did you say? 10?
9:30.
9:30. Mr. Alderman,
Yes.
please be mindful that this is going to be in person, not on Zoom. In
All right, so
person. Pardon?
So I can get the directions and everything from my attorney?
Wait, say again?
So I can get the directions and everything from my attorney?
Oh, absolutely. It's going to be at 36th District Court in person. Please make sure you plan to arrive well in advance of the exam time, because there's, well, likely to be a health screening that might still be in place, and certainly there'll be security screening that you'll need to go through. So I don't want you to be delayed in getting to the courtroom. So please make sure you plan to arrive early and that you would be in person. Ms. Grady will certainly give you any directions that you need in order to facilitate your presence.
All right.
Okay, bond will continue and we'll see you on January 6th. If you have any discovery concerns that arise between then, today's date and then, please make sure that you motion it up before the court, alert the prosecution, and we'll tee it up for a motion.
Okay.
Thank you, Your Honor. Have a great day, you and your staff.
You too.
You too, Judge. Can we
All right, y'all
see
have a
this?
blessed morning.
You too.
Division 1, what's your name, sir?
Hey, John Boyer.
Thank you. Calling parties on Holtzclaw, case number 21580. The people of the state of Michigan versus Trenton, Daryl Holtzclaw. The defendant is charged with count 1, weapons, firearms, possession of felon. Count 2, police officer fleeing third-degree vehicle code. Count 3, assault with a dangerous weapon, felonious assault. Count 4 and 5, weapons, felony, firearms. Count 6, domestic violence, habitual offender, second offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Very good morning, Your Honor. May it please the court, Sharon Clark Woodside appearing on behalf of Mr. Holtzclaw. Today is the date and time for a PCC. We don't object to proceeding via Zoom. We're asking the matter be set for a preliminary exam.
Is your client present?
he was, there he is, he's on the Zoom. Mr. Holtzclaw, there he is.
Here,
Can you state your name, sir?
Trenton Holtzclaw.
Thank you. Okay, madam, what is your pleasure here?
Judge, we're asking for a be set for an in-person preliminary exam.
Thank you. Mr. Bloomer, any concerns regarding this matter, the bond in this matter that might hasten the exam date?
No, there are no concerns at this time. The people are satisfied, and this is a second PCC, and there have been no new issues.
Okay. Can we have maybe a November date, October, November?
Judge, November 22nd at 10:30.
Okay, wait, November. Just one moment, Judge.
Yes, no problem.
I'm still juggling my other docket as well, Your Honor, so
Yeah,
that'll be fine.
okay, great. In-person examination, November 22nd at 10:30. Mr. Holtzclaw, please make sure that you are present in the courtroom on that date, okay?
Okay.
Also, I need you to make sure that you continue to abide by the no contact provision that's in place. No contact directly or indirectly. And that would include telephone, letters, any form of social media outreach or texting or chat, or having anyone act on your behalf to communicate with the complaining witness. Very serious condition, and I really want you to make sure that you're abiding by that, okay?
Okay.
All right, we're all set. Thank you so much.
Thank you. Have a great day, Your Honor, you and your staff.
You too. Have a good weekend, Ms. Woodside.
You too. I'll talk to you, Mr. Holtzclaw.
What is Mr. Riggins?
I'm not sure if there's witnesses or not.
Can we call Ms.
Mr. Bloomer, are we ready to call Riggins?
We can bring it out.
Okay, thank you.
Judge, can we ask Deputy at Division 1?
Yes, Your Honor.
Could we get, this is the clerk, could we get Mr. Hurd first? I had to have the attorneys here on that. I still haven't heard from that person's defense counsel.
Okay, Mr. Hurd is over at Division 2.
Okay, all right, no problem then. Thank you.
You're welcome.
Calling parties on Martin, case number 2061037. The people of the state of Michigan versus D'Angelo Devon Martin. The defendant is charged with count 1 and 2, assault with a dangerous weapon, felonious assault. Count 3, malicious destruction of personal property, $200 or more, but less than $1,000. Habitual offender. Fourth offense notice. This matter is scheduled for preliminary exam.
Thank you, ma'am. Appearances, please.
Jacob Bloomers on behalf of the people.
Hey, good morning, Your Honor. Good morning to your staff, Neighborhood Defender Services by Ken Riggins, P82125, on behalf of Mr. D'Angelo Martin, who's behind me to my right.
Okay, good morning to you, Mr. Riggins. And could you state your name, sir?
D'Angelo Martin.
Thank you. Today's the date I'm set for preliminary examination, set for 9:30, and it's currently 9:37 by my watch. Are we proceeding to an exam?
Your Honor, at this time, the complaining witnesses, Tiffany Colson and Artesia Hodges, are not present in the courthouse. They were subpoenaed to be here for a 9:30 a.m. preliminary exam. Without their present participation, people are unable to go forward at this time.
And based off the prosecution's representation, I move for dismissal.
So ordered. I am going to grant that motion to dismiss. The matter is hereby dismissed without prejudice. So what that means, a dismissal with that trailer language without prejudice, is that it is possible that the prosecution can reissue. Whether or not that happens, I would have no idea. It's just something that I like to explain because it's within the discretion of the prosecution if they follow up and make certain determinations that perhaps there was some superseding reason that prevented those witnesses from coming. It's within their discretion whether or not to reissue. You understand that, sir?
Yes, Your Honor.
Okay. I am going to forward this up to Madam Clerk. I just need your signature, Mr. Riggins, on this order of dismissal. And is there anything further?
Yes, Your Honor. Just one last thing, and it's probably just housekeeping. My client is here on a writ from MDOC. Unfortunately, his current condition is due to him being in the Wayne County Jail. In addition, my client is up for parole, I believe, in September. And MDOC, and he's taking some necessary classes. I'd like to have the writ released as soon as possible so that he may hopefully get his release in September.
Yeah, I don't know exactly what I can do in furtherance of that. Did you want to prepare something in writing? We have blank order forms here. I don't really know how else to.
As long as we release his writ and he's sent back as soon as possible, I think that's satisfactory. I mean, I think with the dismissal of the case, his writ should be released.
Okay, I don't know if that happens as a matter of course. Perhaps the officers can alert us, but if not, there are blank order forms here. Madam Clerk can hand one to you if you wanted to write a proposed order, and we'll go from there.
Absolutely.
Okay, we are all set. Thank you so much.
Thank you.
What do you want? The judge has that.
So now just have to wait till 11 o'clock for.
Oh, you got another one?
Chavez, that's gonna be fun.
Judge.
Oh, yeah.
I got an email from Ms. Parker.
2 interpreters.
She said we have to go 11:30. That's what she said. Yes, wait.
Good morning, Ms. Schneider.
Oh, no, we have Miss Alexa today.
Good morning, Your Honor. It's nice to see you again.
Calling parties on Baruchko. Case number 2158058. The people of the state of Michigan versus Jordan Thomas Baruchko. The defendant is charged with count 1, malicious destruction of building, $1,000 or more, but less than $20,000. This is scheduled for a probable cause conference.
Okay, hold on 1 second. Okay, I'm sorry. Can I have appearances, please?
Good morning, Your Honor. Alexa Schneider for the people, P80322.
And for the record, Brian Schaff, retained counsel on behalf of Mr. Baruchko, P68271.
Good morning, sir. And your client? Your client's name?
Mr. Baruchko. Jordan Baruchko.
Okay, thank you. All right, we're here today.
Jordan Baruchko.
Oh, okay, thank you. We're here today for a PCC. And Mr. Defense Counsel, do you have discovery? Or are there any discovery issues? And what would you like to do today?
We do have discovery, no discovery issues, and we would like to enter a plea.
Okay, there's a proposal here, Madam Prosecutor.
Yes, Your Honor,
There's a-
we are looking. Oh, I'm sorry.
No, there obviously is some sort of delay, there's some sort of audio issues going on. So we'll try to get through this as best we can. I know Madam Court Reporter is trying to make a thorough record, so there's a negotiation that's on the table, is that correct?
Yes, Your Honor, and myself and brother counsel reviewed that recommendation. I signed it with his permission, and I also signed it, and both parties are in agreement. Just to clarify, I made a typo on the first form and said 6 months. It's actually 60 days, which I also emailed to your clerk.
Got it. Okay, and I note here, well, I want you, I have it before me, but I want you to state the fullness. Not that there seems to be much to it, but I want you to state the fullness of the negotiation on the record before we go further.
Yes, Your Honor. The agreement is that the defendant will do 60 days in the Wayne County Jail. He will also pay restitution for the damage caused. In return, we will amend the felony count of malicious destruction of a building to the 1-year misdemeanor count of malicious destruction of a building.
Interesting. Wait, so the agreement is that if he pleads to the reduced misdemeanor, that he's going to serve 60 days Wayne County Jail? In lieu of a fine or court costs and any other probationary term?
The rest of the sentence would be in your discretion, Your Honor.
Okay, well, there's a couple of things I just want to note here before we go any further. I would not be the sentencing judge. There would not, in fact, be immediate sentencing. I can accept the plea, but the sentencing would be before Judge Bryant, I believe. And that would be sometime mid-August, mid to late August. And in the meantime, there would have to be, as a matter of course, a pre-sentence investigation. At which time, Mr. Baruchko, you would be asked a number of questions. There would be a report generated based on your answers. It would be a recommendation to the judge. In fact, it's called a pre-sentence recommendation, notwithstanding the agreement that appears to be on the table here. And the sentencing judge, I have to say, does have discretion to alter, to amend, to add, to take away on any given sentencing that comes before the court. So while there is this understanding of 60 days and done, I have to make sure that that is understood. Is that understood?
Your Honor, if I'm not
Go ahead.
Your Honor, if I'm not mistaken, if the sentencing judge does not agree to go along with that and wants to give Mr. Baruchko more time, he can withdraw his plea at that time, correct?
Yeah, yes. Now,
We're
I
prepared
doubt
to proceed.
Yeah, I doubt that would happen, but I just want to be very forthright with regards to what I'm compelled to say.
And for Mr. Baruchko and his attorney's understanding, that's the people's understanding of the offer as well.
Okay, and let me give an example. For instance, if during the pre-sentence investigation or in the report, it's the recommendation includes some form of mental health counseling or drug addiction counsel, substance abuse counseling, that might be part of a recommendation that the court, the judge could take into consideration. But yes, ultimately, counsel, in the event that there is a sentencing that is proposed to be passed down that is a deviation from what you anticipated, you certainly would be able to withdraw that plea. I just want to have everyone walk into this eyes wide open.
Yes, Your Honor.
Okay, so there are some other questions I do need to ask Mr. Baruchko. Do you understand the allegation against you?
Yes.
Do you understand that you have a right to an attorney, and if you couldn't afford one, one would be appointed?
Yes, ma'am.
Do you understand that you have a right to a trial?
Yes, ma'am.
Do you understand that if a trial did occur, that you could have your attorney cross-examine prosecutorial witnesses? You could even have witnesses subpoenaed on your behalf to testify, and you could even testify on your own behalf if you so desired. Do you understand that, sir?
Yes, ma'am.
Do you understand that if you tender a plea of guilty and this court accepts that plea, that has the effect of giving up, of waiving your right to a trial?
Yes, ma'am.
And is that what you wish to do?
Yes.
Do you understand you can't come back 3 months or 6 months or a year from now and say, I'd like to have my trial in that matter?
Yes, ma'am.
Okay, and has anyone threatened you in any way to get you to give up your right to a trial?
No, ma'am.
Has anyone promised you anything other than this negotiation, reducing the felony to a misdemeanor, to get you to give up your right to a trial?
No, ma'am.
Are you pleading guilty to the misdemeanor because you are guilty?
I'm pleading, yes, I'm pleading guilty.
Okay, this is a different question though. Are you pleading guilty because you are guilty?
Yes.
Thank you. That being said, please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You, Madam Prosecutor?
Yes, Your Honor.
Madam Prosecutor, would you like to establish a factual basis on the record?
Yes, Your Honor. If I can have just one moment.
Oh, yes.
Your Honor, I could establish the basis.
Okay, all right.
Mr. Baruchko, on or about May 16th, 2021, you were in the city of Detroit, correct? Yes. And you spray painted the side of a building, correct? Yes. And that caused damage between $200 and $1,000, correct? Yes. Satisfied, Your Honor?
I'm satisfied. Madam Prosecutor, are you satisfied?
Satisfied, Your Honor. Thank you.
Okay. And I am going to accept that plea of guilty to the amended offense, misdemeanor, malicious destruction of a building over $1,000, but less than $20,000, again, a misdemeanor. And I'm gonna make sure that we keep in this file the plea agreement form, so that information will be relayed to the sentencing judge. Again, that's gonna be Judge Bryant. What sentencing date can we give for that?
September 17th at 9 a.m.
September 17th at 9 a.m. will be the sentencing date. In the meantime, you should be, prior to that date, contacted by the probation department for that pre-sentence investigation that I told you about. I'm assuming it's virtually done, and it's an interview, if you will, that has to be accomplished prior to the sentencing. So if you're getting closer to that sentencing date and you haven't heard from the probation department, it probably is a good idea to call them, just to ensure that you can actually proceed with sentencing on September 17th, because the judge will not sentence without that in hand. In fact, Madam Clerk, can we forward to defense counsel the probation department number so that he'll have it?
Sure.
Are you ready to take that number down?
I am.
Thank you.
It's 313-965-3414.
Okay,
If you could email me or put in chat your client's phone number, that would be helpful that I could pass along to the probation department. And my email is in the chat, up at the top of the page.
okay, I'll send that right now.
All right, thank you.
Thank you so much.
Thank you. Have a good day.
You too. We've got Mr. Sharikian.
Yeah, he's on, Hurd, is that Mr. Hurd? I think that's a different division. If it's Division 2, it should be Mr.
Division, oh, they're connecting, Bobby. What is Mr. Doherty's here?
He's here on that case.
Oh. Deputy, who do you have there? Mr. Hearing, Willie Hearing.
This is Keith Hurd and he's in Division 2.
Thank you so much.
Thank you. Colleen?
Who do you have?
Willie Hearing, I thought you asked me, sorry.
Yeah, I know.
Calling parties on Hurd, case number 2159882. The people of the state of Michigan versus Keith Warren Hurd. The defendant is charged with count 1, carjacking, count 2, stolen property, receiving and concealing $20,000 or more, count 3, motor vehicle, unlawful driving away. Habitual offender, 4th offense notice. This is scheduled for a probable cause.
Thank you, ma'am. Appearances, please. Prosecutor? Prosecutor on Hurd.
He's meeting the judge.
Sorry,
Mr. Doherty.
sorry. Good morning, Your Honor. Dennis Doherty on behalf of the people, P44075.
Good morning.
Good
Your Honor.
morning. Long time no see.
Yeah, I apologize for the mute button.
No worries. Mr. Shrikin?
Good morning, Your Honor. It hasn't been a long time since I've seen you, but nonetheless, it's a pleasure. Samuel Chirikian appearing on behalf of Mr. Keith Hurd. My P number is 29888. And
Always
consent to conducting this hearing through Zoom, Judge.
Okay, and your client, please state your name.
Keith Hurd.
Thank you. All right, today's the date and time set for a PCC. Mr. Shrikian, do you have your discovery material? And if so, what would you like to do here?
Judge, I have no discovery, but I have made that issue. I did tell Mr. Doherty that, and he is going to supply that. I just spoke to his discovery clerk, and they're going to get that to me shortly. I have no discovery, Judge. I now know the charges, all the charges here. I have spoken briefly to Mr. Hurd regarding this matter. I was just retained in this case.
Okay, and I see there's a COD. I don't know what the status is. It looks like nothing has happened yet to the co-defendant. Did you want to schedule for another PCC so you can review the discovery with your client?
I think that makes sense, Judge, and so that I can have a fuller discussion with Mr. Doherty regarding the circumstances.
Okay, what about a week's time?
Let's see.
13?
Judge, I'm doing a live exam at 11, so I can do this at 8:30, sure.
Okay, oh, if you'd rather do it the 12th, that's fine too.
Now, I've got an exam at 9:30 there, Judge, so might as well do it the 13th.
Okay, new PCC, that should have given you an opportunity, hopefully, to have a visit with your client, or at least to communicate virtually with your client before that date. And that's going to be via Zoom. So Mr. Hurd, you're going to Zoom in on that date, just as you did today, and we'll find out the direction that we're going. Was there any other concern that you wanted to address here, Mr. Sharikian or Mr. Doherty?
Your Honor, the people are requesting that right now the defendant is on a $50,000, 10% bond, and we are requesting that that be made a $50,000 bond. The defendant currently has 4 cases pending, including this carjacking. And I was here actually several months ago, and I actually asked for a reduction in bond on behalf of Mr. Hurd, and you granted that. And unfortunately, I've been, it was probably a miss and shouldn't have done that. But I would ask that the bond be changed to $50,000 from $50,000, 10%.
Okay, so on a separate matter, you as the prosecutor His bond to be reduced?
Yes, yes. He had, Mr. Hurd had some significant health problems, I understand, and I have the utmost confidence, Mr. Sharikian, we talked about it, and at the time it sounded like the right thing to do, but when he picked up this other case,
Do we have the updates?
We have.
We have all. Just wanted to
yes,
make
I
sure
think
that-
they're set for exams in November, 3rd and 4th, or 4th and 5th, or something, in November. So there's 3 cases that are up for exam in November. One of them is.
May I be heard, Judge?
Oh, yes, I wasn't sure if the audio had,
Judge, what's his
Mr. Doherty had finished.
What's his birthday?
12/21.
Okay.
Yeah. Mr. Shrikian, yes, please.
Judge, Mr. Doherty is correct. We did come before the court at an earlier date, request a reduction in the bond. The court was kind enough to grant that bond. My client, Mr. Hurd, was the victim of an assault where he was shot numerous times. He's got limited use of one of his arms. And in fact, I'm going to ask that the court order that he be allowed, or his people be allowed, to deliver a arm sling to the jail, because he's in a great deal of distress regarding that arm. Judge, I certainly can't justify or condone any new criminal activity, but right now it's just an allegation. I haven't seen the discovery, so I can't really address what the allegations are specifically, Judge. But I think that the present bond is sufficient.
Well, okay, so now we're looking at a situation where the defendant, and I have to be completely candid with you, as I look at the allegations, I am quite shocked. But for the information you just relayed, I am, the bond is just incredibly low. The potential pattern that is before the court also, that the defendant has picked up another allegation, let's call it, is very troubling. And I have to make sure that the bond is commensurate with what is before the court, the information before the court. And with this information that I'm receiving, and as I look at the allegations, I am concerned about the bond being only 50,000, 10%, and I do not see, oh, there is a test imposed. I'm curious though, Madam Clerk, this information that Mr. Doherty's saying, that he came before the court and I granted a reduction in bond, I don't see that I did that.
Judge, I believe that was on another case.
It was on another case, Judge.
It was another, yeah, it was one of the 4, now there's 4 cases pending before you. So it was on one of those other cases.
Oh, Judge, or?
No, it was Judge, it was you. It was on one of the 4 cases.
Oh.
One of the 3 cases. I'm sorry, this 4th case is new, so.
Okay, all right. Well, I am going to increase the bond. I think that it's appropriate here. As I look at, and let me just be clear for the record, I'm looking at the 4 corners of this file. And I'm looking at the fact that the magistrate set the bond at 50,000, 10% on this case. Carjacking. I just don't even see where the reasoning would come in to set it at 50,000, 10%. There is a total of 3 counts, 3 felony counts that the defendant is facing, coupled with the fact that the defendant is listed as an habitual offender. And that's just looking at this file alone, not even taking into consideration the other 3 files. But the fact that there are 3 other pending matters is very concerning to the court. But my focus is on this file, and I do believe that the bond should be increased from what the magistrate set. So I am going to increase the bond to $50,000 cash or surety with GPS tether, with no contact with the complaining witnesses. And you said that the other matters are set for exam sometime in November, but Was that November date given when he was in custody?
No, Judge, no.
No, I don't think he was in custody when those dates were given.
We need to alter the date because now that he is in custody, the timing of this exam takes priority over other matters, and we can give you a date. It's not gonna be an easy process to find a date, but if there's a date within the next, I don't know, 14 days, you would like to.
Well, that's going to be impossible, Judge. I couldn't possibly be prepared to conduct numerous exams within the next 2 weeks. As the court is well aware, I'm pretty jammed up right now.
I understand. I just want to express that this court is trying to take into consideration the fact that he's in custody, and I don't want to turn a deaf ear to that. So would you like to hasten the date at all, or did you want to keep it in November?
Well, we can leave that alone for right now, Judge. I need to talk to Mr. Dory about this case, find out what this case is all about. I am totally blind in terms of what's going on with this case. I do note that there is no felony firearm count, which is reassuring. And as the court is well aware, the carjacking statute is very broad. So any force whatsoever raises the charge from UDAA to carjacking. And so I don't know the nuances of the allegations here. And so I'd ask the court simply to give us that new PCC date, and then we'll be better able to address timing in terms of examinations at that time.
Absolutely. Okay, so we'll keep that date for new PCC, August 13th at 8:30. And if there's anything else that we need to be aware of prior to that time, let us know. We'll hopefully have some sense of direction when we return on the 13th.
Thank you, Judge. We appreciate that.
Thank you, Your Honor.
Thank you. Oh,
Thank you.
Mr. Doherty,
Yes.
do I have permission to sign your name to the motion to increase the bond?
Well, please do. Thank you, Your Honor.
Thank you. Both sides will get a copy of this amendment.
Thank you,
Judge.
Calling parties on Henry, case number 2062772. The people of the state of Michigan versus Willie Kent Henry. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons carried concealed. Count 3, weapons, felony, firearm, habitual offender, third offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Yahuki on behalf of the people.
Good morning, Your Honor. May I please the Honorable Court, Stephanie White, key 82135, appearing on behalf of Mr. Henry.
Morning to you. And could you please state your name, sir?
Yes, good morning. My name is Willie Henry.
Okay. Today is the date and time set for an examination in this matter. Are we proceeding to an exam?
Your Honor, at this time, the people are not ready to proceed. Sergeant Ziola had been notified to show up to court, but he just indicated this morning that he's still out of town. So without his presence and participation, people are unable to proceed.
Counsel?
Your Honor, we're asking for dismissal. We are ready to proceed.
Okay. Today is the date and time set for a preliminary examination. Let me just say that I am hearing that the officer that's necessary is not here because he's out of town, but I don't know that I've heard anything that would rise to the level of good cause to adjourn. So I'm not sure if you're asking for an adjournment or if perhaps this was something that was an emergency, or I don't know. So at this point, I'm willing to entertain this motion because I haven't heard more fullness of that explanation.
Well, based on what the OIC in this case had told me is that he was still on vacation, so I'm not sure that's an emergency, Your Honor. But he was subpoenaed back in February.
Okay.
Your Honor, yes, this exam was set back in February.
Thank you. Okay, so certainly, I'm gonna grant the motion to dismiss because this matter was set many months ago, and certainly and I don't mean to suggest that this is the fault of the prosecution, but there has to be a better nexus between the prosecution and the officers and notification for hearings, because I'm finding on many cases that come up before the court, it's determined that the officer is on furlough or otherwise, and cannot be here, and that should be something that is hashed out in advance of having Madam Defense and the defendant come down here, for which certainly an adjournment would have been more appropriate had we known in advance. But hearing this on the date and time of the exam is troubling. I'm going to grant the motion to dismiss, but here's what you need to take away from this. While it's dismissed, and that word dismissal has all the bells and whistles around it, there is some trailer language that follows. That is dismissed without prejudice. And what that means is that it is possible that the prosecution can reissue on this very case that was dismissed. Now that sometimes can be a confusing concept. So I want you to make sure, sir, that you speak with your attorney about the fullness of that concept, the how, the why, and the parameters of that. Because certainly the prosecutor could go back to her office, speak with the necessary officer witness, and make a determination. It's within their discretion as to whether or not to reissue. So just be very mindful of that. And also, do you have a GPS tether that needs to be removed, sir? Okay. Madam Defense, I need your signature on this order of dismissal. And we'll be all set. You can have a seat in the hallway, sir.
Calling parties on El Kadard, case number 2159811. The people of the state of Michigan versus Hakeem El Kadard. Defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence, habitual offender, fourth offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Brian Gagnick, Your Honor, Neighborhood Defender Services, P64220.
Good morning, Mr. Gagnon, and your client.
Hakeem El Kadard.
Thank you. Oh, state your name one more time, sir.
Hakeem El Kadard.
Thank you. Mr. Gagnon, what's your pleasure here?
Your Honor, I need discovery and I'd like to ask for an in-person exam date, please.
Okay. Can we make sure that discovery gets to counsel straight away?
Absolutely, Judge. We'll get paper discovery to Mr. Gagnon this morning. It was sent to NDS Central Discovery, however, I will send it directly to Mr. Gagnon, and then I will follow up with digital.
Thank you. And do you have any concerns regarding bond that might affect the timing of the exam, Mr. Bloomer?
No, Your Honor. At this time, people are satisfied with the bond.
Okay. If we could have a date sometime in late October or early November.
Your Honor, I happen to be in your court. I know that scheduling is very difficult in today's climate. I know I'm in your court on October 20th at 11:30.
Okay, can we make that work?
We can.
Okay, October 20th, we'll say at 11.
I take it.
All right, sounds good. Thank you for that suggestion.
Thank you for accommodating.
The bond will continue. Mr. El Kadard, please make sure that you continue to abide by that no contact provision, not direct contact, not indirect contact, no form of social media outreach, letters, telephone, texting, chat, or even having anyone act on your behalf to communicate with the complaining witness. That's really important. Even if the complaining witness comes to your doorstep, you are still not permitted to engage with the complaining witness while this case is pending. Do you understand that?
Yes, Your Honor.
Okay, thank you. Mr. Gagniak, if there's any concerns that arise between now and then, then meaning the exam date, please just notify prosecution and the court, and we'll tee it up for an appropriate motion.
Thank you.
Okay, thank you.
Thank you. Thank you.
You're welcome.
Ms. Carteret zoomed in on Mr. Boyer, but now I don't see Division 1.
Let me see if they're in the waiting room. I don't think I have anyone in there. No, I don't.
I'll call the jail and see if I can get Mr. Boyer back up. It looks like they signed off for
Oh, was
some,
he up yesterday?
he was, and he's up to date on the tether violation. So I'm thinking they went and picked him up.
Oh,
He
okay.
missed his court date. But he was on earlier and now I don't see Division 1, so I have one more minute to call him here. Calling parties on Mathis, case number 2158417, the people of the state of Michigan versus Demetric Mathis. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. We might have to on behalf of the people.
Your Honor, if it may please the court, Wayne Frost representing Mr. Mathis, P51-457. I do have the paper discovery on this. It does not look like there would be any digital discovery that would be of any use at this time. However, Judge, I have called my client and left messages. It seems to be a valid number, but I've left several messages, including this morning, and I have not received a phone call back. I have not written a letter, so I'm kind of in limbo here, Judge. I would request an adjourned date in order to write a letter to my client if the court would be willing to do so.
Absolutely. So let's set this for 2 weeks off.
That would be fine.
Okay, August 20th, or did you want to pick a date somewhere in that range?
The 20th would be fine, Judge. I'll make it work.
Great. New PCC, August 20th at 8:30. And if you do get in contact with him, please let him know that we'd like him to join the party here.
Thank you.
You're welcome. Take care.
You too.
Calling parties on Watson, case number 2156176, the people of the state of Michigan versus Drockwell Watson. The defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. Count 2, assault with a dangerous weapon, felonious assault. Count 3 and 4, weapons, felony firearm. Count 5, domestic violence. This is scheduled for preliminary exam.
Thank you, ma'am. Appearances, please.
Jacob Williams on behalf of the people.
Good morning, Your Honor. If it please the court, Attorney Andrea Fanning, P42853, appearing with my client, Mr. Watson. Mr. Watson, can you identify yourself for the record, please?
Thank you. Today's a date and time set for preliminary examination. It was set for 10 a.m. and it's currently 10:16. Are we proceeding to an exam?
Your Honor, at this time, the complaining witness, Talia Vance, is not present in the courthouse. She was subpoenaed to be here for a 10 a.m. preliminary exam. Without her present participation, the people are unable to go forward at this time.
Your Honor, in light of that, we will move to have this matter dismissed.
Okay. Given the time frame and those representations that have been made by the prosecution, I am going to grant that motion to dismiss. Keep in mind that this matter is dismissed without prejudice. And what that means is that it is possible that the prosecution can reissue. If you have questions about that concept, please make sure you speak to Ms. Fanning to get a better understanding, okay? It's really important. I think it's really important that people understand that. In the off chance it does get reissued, that can be quite an unnerving experience to learn, because you think back on August 6th, the matter was dismissed. Why am I seeing this come back up? Please make sure you ask any questions of your attorney about that, okay? Do you have on a GPS tether that I need to remove? Do you have on a GPS tether?
No.
Okay. Ms. Fanning, I do need your signature.
Yes, Your Honor.
As the moving party on this dismissal.
Yes.
And I'm gonna hand this up in just one moment. And sir, you can have a seat in the hallway, Mr. Watson.
Mr. Watson, have a seat in the hall.
This is for Ms. Mr. Hall, good morning to you, sir.
Thank you. That lavender. Thank you.
So pretty.
Thank you. What courtroom is that for?
336?
336, thank you.
Yeah.
Okay.
I mean, if you'll wait a second, I'll look at the docket.
Okay, thank you.
I don't get out much. So.
Right.
I don't know. I was right, 336.
Okay, thank you.
All right. You hear, Williams?
Yes.
Have we seen Ms. Bates or Ms. Upshaw, Mr. Upshaw?
No, I was in gallery, no.
Well, they're up on, in person.
Upshaw's associate is in the hallway.
Bates is outside.
Is she out there?
Yes, she's out there.
Okay, so when we do this one, then I guess we'll do that. Calling parties on Williams. Case number 2059694, the people of the state of Michigan versus Keontae Williams. The defendant is charged with count 1, weapons carrying concealed. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Remind Cookie on behalf of the people.
Thank you, Cyril Hall, on behalf of Mr. Williams.
Thank you. Mr. Hall, could you give Madam Court Reporter your P number?
29121.
Thank you. Sir, could you please state your name?
Keontae Williams.
Thank you. Today's date and time set for an examination. Are we proceeding to an exam?
Your Honor, at this time, the people are not ready to proceed. Police officers have been subpoenaed and notified to show up to court and have not done it.
Is there a motion?
Yes, Your Honor. Your Honor, respectfully move for the
Okay, this matter was set for, what time is it set for?
10 o'clock, Your Honor.
10 o'clock, and it is currently 10:20. With those representations being made, I am gonna grant that motion by your attorney to dismiss this matter. The matter is dismissed. Keep in mind, though, it's dismissed without prejudice. And what that trailer language after the word dismissal means is that it is possible that the prosecutor can reissue.
Okay.
Because we know, being dismissed because the officer's not here, but we don't really know why the officer's not here, and there could potentially be a plausible explanation. So that's within the prosecutor's discretion if they wish to follow up on that, and if they deem it's appropriate to reissue. Okay, I always like to explain that because in the off chance it may get reissued, that can come as quite a shock. Because you think back on August 6th, today's date, when it got dismissed, right?
Yes, ma'am.
So if you have any questions regarding that possibility, please make sure you speak with your attorney.
Okay.
Do you have on a GPS tether that needs to be removed?
No, ma'am.
Okay. You can have a seat in the hallway, Mr. Williams, and Mr. Hall, I need your signature on this order of dismissal.
Are there witnesses on Corinne Clark?
I'll double check right now.
Judge, you're pretty well guarded in here.
Yeah, well, we're trying.
White, gray, okay.
If you mean like in comparison to other courts?
She's checking to see
Yes.
if there's
Yeah.
witnesses on Clark. Corinne Clark.
They're not outfitted like
Mr.
this?
Blake out there?
Not so much.
Not
This
so
is
much?
pretty good, so.
Okay. Here you go, sir.
Although I haven't been to court much.
No?
I went to Macomb County for a settlement conference the other day. And,
Yeah.
they're not wearing masks
Oh,
or
wow.
anything. I mean, I was the only person in the building with a mask. So, what's going on? And they were looking at me like I was
That's
strange.
really, that's scary. You're mainly in Oakland though, right?
No, here now, I've been in Dearborn. for 10 years.
Oh, okay.
But I guess it's the politics maybe.
It
where I was at
is.
at the time.
Listen, I'm trying to just remain safe. Nothing wrong with that. Erring on the side of safety and caution. Ms. Bates, would you agree?
I absolutely agree.
Is never wrong.
I agree with, Mr. Hall, in my hometown, they don't, nobody wear that.
Wow.
In the district court, or
Well, I don't even think in any of the other Wayne County.
Hello,
districts they
Carmen.
are.
Judge Archer, how are you? How you doing?
Good to see you.
It's so good to see you.
Last time I saw you, see you later, Ms. Hall.
It's like-
Take care.
Like-
Last time I saw you, you were in here and you were like, I'm never coming back.
My
Melanie, how are you? I don't recognize anybody with a mask anymore. We all look like bank robbers.
Ms. Cateray, are you going to need a breakout room with Mr. Boyer? Hi, Ms. Division 1.
Yes, Your Honor, we have Mr. Boyer in front of you.
Thank you. Ms. Cateray, did you breakout room with Mr. Boyer?
Yeah, I can, thank you.
Right here.
And I'm just assuming, so has this report been forwarded to me?
I did not receive a report, Judge, so I couldn't forward it. I asked for one this morning and as of right now, I haven't received one.
Gotcha.
I was hoping the deputy could enlighten us on what's going on.
Okay, now.
Did we solve the problem?
Yeah, my balance was off. It's the pending too.
Okay.
PCC, defendant home bond, defendant on Zoom. And new PC on the 13th at 8:30. See, nothing, that was on the second, but nothing in my hand.
Oh, okay.
So the judge did do it, so I can
Okay,
tell
I'll fix
Judge
it.
Jefferson.
You want to
that
send him back down here?
Send everything back down here.
Okay.
Let me just take this so I can show her. And
Okay,
then
no problem, and I'll fix it.
Okay, thank you, Tammy.
All right.
Bring it back, okay?
Yep, no problem.
Thank you, Judge.
You're welcome.
Are they in a breakout? Yes. All right, I guess we can call this case then. Are we ready, Andre?
Yes. Sorry.
All right.
This is, yeah.
Is this a hold?
Gray as a whole.
Okay.
That's
Mr. Bloomers, do you have a violation report on Boyer?
No, I didn't get any kind of report. Like I told Tammy, my OIC on that case was
Ms.
here.
Cateray? Can we call that before we do it? Yes, look, call this, Tammy, was there something else? Oh,
You
okay.
have it, I think.
Calling People versus Najon Boyer, 210-595-811. This is a matter in which is teed up right now for a tether violation hearing. The defendant is charged with count 1, assault with intent, assault with a dangerous weapon, felonious assault, count 2, domestic violence. Appearances, please.
Jacob Bloomers on behalf of the people.
Danielle Cateray, P77162, good morning, on behalf of Najon Boyer.
Good morning. Mr. Boyer, please state your name.
Good morning, Najon Boyer speaking.
Good morning to you, sir. Okay, we're here today for a tether violation, but I'm just wondering if the tether violation is that he did not appear for court.
That's my belief. The officer in charge on this case was present yesterday, and after he was found capious, she said, I'm going to his address, to see if he's there to pick him up. So my guess is that's why he's in.
Deputy, can you hear us? If so, we never received an actual report, and we're just assuming that the alleged violation is that he did not appear. He was capious yesterday for his exam.
Okay, yes, I can hear you, Your Honor. So you say you never received the actual tether report?
No, wait, let me just look through again. I don't have anything.
All right. All right, can you confirm an email, because our my partner stated that they sent it already?
They sent it, what's the email?
I never received it.
Excuse me, Your Honor, my partner said that he sent it to your email. I don't know if it.
Got it.
She got it. Okay, thank you.
Okay, so I'm going to.
You can send it to me.
Yeah,
I'll
thank you.
print it out and I'll send it to Ms. Cataray. Yeah, I gave them my email this morning, but.
Okay, I just sent it. We're gonna get it to Ms. Cataray, and Mr. Bloomers will get you a copy.
Thank you, Judge.
And let me know if there were photos. Let me know if those photos came through as well.
Don't see.
You don't see photos?
No.
Wait, let me try it again. Are you sure? Did you scroll down?
Yeah, I scrolled. There's just the tethered violator.
Because I think the pictures are pretty important now that I see it.
Oh, okay. Yeah, I don't. Oh.
You see it now?
They're not attached.
But you see it though, right?
I do see. So let me see if I can just print this whole thing.
Yeah, and see if, can that be forwarded to Ms. Cataray as well?
Yeah, I'm just gonna forward the whole. Yeah. Ms. Cataray?
Yes.
When you, the actual report was sent as an attachment, but if you just scroll down, there's actual pictures that's not attached. It's part of the email. So you'll have to just scroll down.
Okay, I see them.
Okay, and I know, Ms. Bates, you're ready to proceed in this matter, right?
Yes, sir.
We're going to break in between, let's say, I don't know, the first, how many witnesses do you have? Just one?
I think it's this one.
It's just one, Judge, yeah.
Okay.
Once. Your Honor?
Yes.
I apologize. Madam Prosecutor said that the Mears case will be dismissed, so can you do that real quick?
Oh, absolutely. Is that your case, Mr. Glenn?
Yes, Your Honor.
Okay, let's handle Mr. Glenn's case and then we'll pivot back to Ms. Cataray.
I'm sorry, Ms. Bates.
Thank you, officer.
Okay, go ahead.
Calling parties on, is it Myricks or Myricks?
Myricks.
Myricks. Case number 2062734. The people of the state of Michigan versus Jalen Markel Keith Myricks. The defendant is charged with count 1, weapons carrying concealed. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Remand on behalf of the people.
William Glenn on behalf of Mr. Myricks, P36794.
And please state your name.
Jalen Myricks.
Thank you. Okay, today is the date and time set for a preliminary examination. And this matter was set for an exam at 10:30. It is currently 10:34. Are we proceeding to an exam this morning?
Your Honor, at this time, the people are not ready to proceed. Police officers have been subpoenaed to show up to court and have not done so.
Move to dismiss, Your Honor.
Okay, the motion is going to be granted. The matter is going to be dismissed due to those representations, Mr. Myricks. Please understand, however, that it's dismissed without prejudice. And what that means, in short, is that it is possible that this can be reissued. If you have questions regarding that concept, please make sure that you speak with your attorney and he will answer your questions for you, okay?
Yes, ma'am.
Do you have a GPS tether that needs to be removed?
No, ma'am.
All right. Counsel, I will need your signature as the moving party on this order of dismissal, and then we'll be all set. You can have a seat in the hallway, Mr. Myers.
Thank you.
You're welcome. Okay, this is for.
Mr. Dillard should be coming up on the, Clark matter. Mr. Bloomers. Mr. Dillard just called, he was on his way in, on Clark.
I got at least 2 holes in front of me.
Okay, are you ready to address the Boyer matter?
People are ready.
Ms. Cataray, are you ready? Oh, okay, all right.
Yes.
Recalling people versus Najon Boyer. This is, again, 1059581. Appearances again.
Jacob Bloomers on behalf of the people.
Danielle Cataray, P77162, on behalf of Najon Boyer.
Mr. Boyer, please state your name.
Good morning, Najon Boyer speaking.
Thank you. Okay, so I believe that both prosecution and defense have now been supplied with the tether violation report. What is your posture on this, Mr. Bloomers?
Well, Your Honor, Mr. Boyer had preliminary examination set yesterday morning. He failed to appear for that examination. A habeas motion was made by the people, which was granted by this court. Then, according to the tether report, at about 1 p.m. yesterday, there's a tamper alert on Mr. Boyer's tether. They go to his address, they find him, and as the court can see from the pictures, his tether is heavily damaged. It appears he tried to remove it after he failed to appear for his preliminary exam. Given all of this information, the people would move for a bond to be set at $100,000 cash, no 10%, and GPS tether and house arrest should bond be made.
Ms. Cataray?
I believe you set his bond at $20,000 cash. I don't, he can't afford $1,500. So I don't know why the excessive and arbitrary number of $100,000. I'm just asking that you keep the bond at $20,000 and set a preliminary exam in person as soon as possible.
Okay. I am troubled by the fact that we had an exam date scheduled for yesterday and Mr. Boyer failed to appear. That's my first level of concern. And this is a very serious matter, Mr. Boyer, for which you are facing count 1, felonious assault, count 2, domestic violence, the misdemeanor. And for you not to show up on your exam date is what prompted the warrant from being issued. Capious is how we refer to it. So that's my first level of concern. And so your bond was revoked, your bond that was set at, what was the original bond? $20,000. No, that was what we just did. $15,000 with a 10% provision and a GPS tether. That's what was originally in place. That was revoked. And new bond was set at $20,000 cash assurity. So then, in the meantime, between yesterday and today, it comes to light that obviously not only that you missed the court date, but that there is an inference that there's been some attempt to damage and or remove that tether by way of the pictures that were sent and attached to that report regarding the tether. So that brings another layer to the concern that to the court's attention that was not in place yesterday. So I do understand, Ms. Cataray, your position that the bond should remain at $20,000. And ordinarily I would agree and say, yes, it it should remain $20,000 cash surety. He's here now. And let's get this on track. The bond is gonna remain. But with that new information, by way of just looking at those photos after there was a tamper alert given to the tether unit, that is what causes greater concern. So I'm going to increase the bond for that reason. It reflects to me that, Mr. Boyer, you are showing an extreme disregard to not only what you're facing, but the court's orders. So I'm not going to increase it to $100,000 cash surety. However, I am going to increase it to what I deem is appropriate, given the circumstances before the court, and that is $50,000 cash surety. We do need to get this back on track, and that's with the GPS tether in the event you are able to post bond. We do need to get this back on track for an examination, and I would ask Ms. Cataray if you can select a date that at least gives 7 days notice for the prosecution to provide notice to their witness. Would you like to select a date?
Yes, I am, I'm there. I have an exam in Judge Jones a week from today on Friday the 13th at 9 a.m. If you have a Friday, maybe 10 or 11 available.
Mr. Bloomers, 7 days, okay? We're gonna set this for August 13th at 10 a.m. In-person examination. Witnesses or witness must be present in person. And we will proceed from there.
Excuse me, Your Honor, Mr. Boyer would like to speak with his attorney before we log off.
Oh, sure. Was there anything further, Ms. Cataray, that you want to address on the record?
Yes, just one other thing. I believe there's a 911 call in this case, and I received all the video, but I did not receive the 911 call. So I'm just asking Prosecutor Bloomers if he can send that if he has it, or if he can get it.
Mr. Bloomers?
Yes, I know I ordered them. I believe I did send them, but I will resend them.
I have video. I just don't have a 911 call.
Yeah, it would have come separately, but I will follow up. I'll make sure you have it.
Thank you.
Thank you.
Okay, I'm going to put you in a breakout room with your client. If it's necessary to go back on the record, just let us know. If not, you can just depart from there.
Thank you.
You're welcome. Okay. Hi there. Did you have something ready? Did you have something ready? If you have a quick matter, we can proceed with that. Otherwise, we're going to start a hold Ms. Bates' client.
Well, it was an issue in regards to discovery, but I guess he's not gonna address it right now. Because I'm asking for an adjournment because I don't have all the stuff.
Oh, okay. If it's going to be a quick matter, then we should maybe do that now before we commence with the examination. Maybe, no?
Well, I mean, we can address it. My position would be discovery is complete when we should hold the exam when people are ready. But
Okay. Well, then just hold 1 second. This is a one witness examination. Ms. Bates has been so patient. I appreciate you. Okay, we're gonna call this matter and then we'll proceed.
Calling parties on Gray, case number 2159457. The people of the state of Michigan versus Anthony Gray. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence, habitual offender, second offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
And good morning, Your Honor. Melody Bates, appearing on behalf of Mr. Anthony Gray, who would be trying me for my right.
Could you please state your name?
Anthony Gray.
Thank you. Okay, Mr. Bloomers and Ms. Bates, are there any preliminary matters before we commence?
None for the people, Judge.
Nothing from the defense, Your Honor.
Okay, first witness.
Your Honor, the people called Darlene Caldwell to stand.
Right here. Over here. Right here. Please state your name, your first and last name,
Darlene Caldwell,
and can you please spell your first and last name?
DARLENE, CALDWELL.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. You can come over here, and this little half gate swings open towards you. Watch your step coming up, and once she's settled, you may proceed, Mr. Prosecutor.
Good morning, Ms. Caldwell.
Good morning.
Could you please state your full name for the record?
Darlene Caldwell.
And Ms. Caldwell, on or about the date of July 9th, 2021, that morning, where were you?
I was at work. I
Okay,
left work.
well, I'll stop you there. You were at work?
Yes.
Why did you leave work?
Okay, what did you, repeat your question, please?
Okay, so, on the morning of July 9th, 2021, you stated you were at work, correct?
Yes.
And why did you leave work?
I left work because Anthony Gray had texted me
Okay, and,
about a phone.
okay, and so I'm gonna stop you there. You say Anthony Gray. How do you know Anthony Gray?
We lived together,
Okay, what's the nature of your relationship?
boyfriend, girlfriend.
Okay, how about how long have you known him?
About I'm going on 5 years.
Okay, were you dating that whole time, or?
Yes.
Okay. Do you see Mr. Gray here in the courtroom today? If you need to stand up, you can.
Yes.
Okay, could you please point to him so the judge can see and just describe what he's wearing?
Anthony is over there. He has on the mask, the green shirt, white t-shirt.
All right, thank you. Let the record reflect the witness identify the person of the defendant.
The record will reflect identification of the defendant.
Okay, so you say you received text messages or calls from?
I received a text message.
Okay, and what was it regarding?
It was regarding a Obama phone.
Okay, a phone. And what was it about that phone?
Because I had the phone.
Okay. And so what did you do after you received that text?
After I received the first text, I asked him, what is he talking about?
Okay.
Then he texted me back. Trying to keep my mask up. He texts me back. He says, so you gonna play dumb? You don't got my phone. After that, I did not text him back. I left my job, I walked home.
Okay, so I'm gonna stop you there. Your home, is that the address of 20267 Graydale?
Yes, it is.
And is that in the city of Detroit, County of Wayne?
Yes, it is.
Okay, so you say you walked home?
Yes.
All right, so what happens when you arrive at that?
When I got to the house, Anthony was sitting in the den. I walked in, I said, what are you talking about? He said, you got my phone, you calling people on my phone. I said, no. I called one person, which I knew who that was, this young lady that he has been cheating around with. I said, I did not call anyone else on your phone. I know who I called. I said, I was waiting on you to come to me because I've been had it for like 3 or 4 days. So now I know you're still talking to the young lady. After that, he got very aggressive.
Okay, so I'll stop you there. Where in the house are you at this time?
We're in the den.
The den?
Okay.
Is that on the ground floor, basement?
Yes, on the ground floor.
Okay. And so you say he starts to get very aggressive. What happens next?
He started screaming, he started hollering. I said, I'm only trying to talk. That's all I'm trying to do.
Okay.
Then,
So what did you do next?
after that, I sat there, my keys, he had the little cocktail table. He had some food on the cocktail table. My keys, my car keys sitting on the cocktail table. I grabbed my car keys.
Okay.
Anthony jumped up when I grabbed my car keys.
So at this time, when you grab your keys, are you standing or still
I'm
sitting?
still sitting in the recliner.
Okay, and you say he.
Double recliners.
Okay, and you say he, where is he at this time?
There's double recliners.
Okay, and he's in the other one?
He's in the other one, I'm in one.
Gotcha. So you grabbed the keys, you said he jumped up. What happened
Jumped
next?
up out the recliner, he started choking me.
Okay,
First, he had both his hands around my neck, choking me. And I couldn't breathe. My head went back. My eyes was going in the back of my head. I could not breathe. He kept saying, turn him loose, turn him loose. Turn him loose. I would not let the keys go.
okay. So when, sorry, I'm gonna stop you there. When you say turn him loose, that's you referring to the car keys?
Yes,
Okay. And you stated he at first was choking you with both hands?
with both.
Okay. And were you able to breathe while he was doing it?
No, I wasn't able to breathe.
Okay. What were you experiencing while that's happening?
I'm gasping for air, telling him, crying to tell him I can't breathe.
Okay.
So at that time, he took one hand off. He tried to pry the keys out of my hand. I still wouldn't let the keys go.
Okay. So you say he took one hand off.
Judge, I'm sorry to interrupt you. This is Division 1. Are you done with Mr. Boyer?
Yes, sir. Oh, wait, Ms. Catherine, were we done with Mr. Boyer?
No, I think he wants to make a motion to recuse the court, and he wants a new attorney.
Okay, give us just one moment, Deputy. We do need to go back on the record, okay?
All right, thank you.
Okay. Okay, it'll just be a moment. We're actually in the middle of another matter. Mr. Bloomers, please proceed. I'm sorry.
Okay. So you said he took one hand off and put it on your hand with the keys. What's he still doing? What is he doing with the other hand?
Still choking me.
Okay. And are you able to breathe when he's got the one
Still
hand?
not able to breathe.
Okay. Do you know how long he was choking you for?
You know, when a situation like that, I'm gonna say about 5 minutes or so. I don't know.
Okay.
But 3, 4.
Yeah. Well, let me ask you, did you pass out?
No, I did not pass out, but I could not breathe.
Okay. Did you feel at all like you were going to pass out?
Yes, I did.
Okay. So at this point, he's got one hand on your throat, one hand
Trying to try the keys out.
What happens next?
After he couldn't get the key, no, he says, I'm going to choke you until you die. After he couldn't get the keys out of my hand, I had my other keys, my work keys, the other house keys and everything on another ring. They fell on the floor. He grabbed them up. He says, I am going around to your job and I am going to F your job. Anthony left the house, walked around to my job.
Okay, well, I'm gonna stop you there. What did you do after he left the house?
After Anthony left the house, I called the police.
Okay, and did the police arrive?
Yes, they did.
Okay, did Mr. Gray come back before the police arrived?
He came back with the police before the police got here.
Okay, was there any more altercation between you two?
It was just a few words, and he says he was gonna burn the house down and stuff.
Okay, but nothing physical at that point?
No.
Okay, no more questions, John.
Cross-examination.
Thank you, Judge. Ms. Caldwell?
Yes.
Now, again, I want to take your attention back to this occurred allegedly on July 9th, correct?
Yes, it did.
Okay. And this occurred at, is it your home or both you and Mr. Wright's home?
Both.
Both of your homes? Okay. Now, you were speaking about a phone that you had taken, correct?
Yes.
Okay, and this phone belongs to Mr. Bright, correct?
Yes.
Okay. And he confronted you about the phone?
Yes.
And that was by text? That was by text?
Yes.
Okay. And, based on those texts, you went back to your home to confront Mr. Gray, correct?
Just to ask him what he's talking about.
To ask him what he's talking about. Okay. So you went back, were in the home, and you were asking him what he was talking about, correct?
Yes.
Okay. Now, you indicated that it was about him allegedly cheating on you, correct?
Yes.
Okay. And you stated that this had been going on and you about had it, correct?
Yes.
So at this point, you are upset and angry, correct?
No, I wasn't upset and angry.
You wasn't upset and angry
No,
about
I
him
wasn't.
allegedly cheating on you?
I wasn't upset and angry about that incident. No,
Okay.
I wasn't.
Then why did you confront him about it?
I didn't confront him. I asked him a question as to what are you talking about?
Okay, so he responded to you, correct? And gave you the information, correct?
Yes,
Okay. And, you stated that he was getting aggressive, correct?
yes, he was getting loud and aggressive.
Okay, so you're saying that he was getting loud and aggressive and you was just standing there just calm with it?
I wasn't standing, I was sitting.
You were sitting?
Yes.
You weren't getting angry either?
No, I just asked him if that's where you wanna go, that's where you wanna be, then go ahead. Why do you gotta get all loud?
Okay.
We're just
But
talking.
at that point, you guys were talking, correct?
I was talking, yes.
And so again, you were accusing him about infidelity, correct?
Yes,
Okay. And, you, at that point, you said you grabbed your keys from a little table?
yes,
This table was in between you two?
yes, the cocktail table, it's a little table that you eat off of.
Okay. And, so then at this point, when you grabbed the car keys, you're stating that he just jumped up and started choking you?
Yes, he did.
Okay. So at the point when you two were just talking, nothing occurred in between that time, correct?
Nothing.
Okay. So he just all of a sudden just jumped up and started choking you?
When I took my car keys,
Okay. And then at that point, you indicated that he started choking you with two hands?
yes,
Okay. And you're sitting in this, I think you referred to it as a
recliner.
recliner. So how is he choking you in this recliner?
I am sitting in a recliner. He's got his hands around my neck. My head is back. Like that. I got my one arm out like this, holding on to the keys.
Okay. So now, Ms. Caldwell, you're not a dark skinned woman. It seems like you're more of a brown skinned woman. Correct?
Yes,
Okay. And you're indicating that he has both hands around your neck, correct?
at that time.
Okay. Now, you also indicated that, when the altercation was over, you contacted the police. Is that
Yes, I
correct?
did.
Okay. And when you contacted the police, one of them in particular talked to you alone, correct?
Yes,
Okay. And I believe there was a female officer that talked to you.
yes, it was.
Okay. Now, at this point, has this officer taken any photographs of your bruises?
I think, yes, I sent the photograph to, the prosecutor that called me that morning.
Okay. So when you say you sent the photographs, are these photographs that you took or are these photographs? that
It's
the
a photograph that someone took for me,
When you say someone took for you, who took these photographs?
a friend of mine.
A friend of yours took these photographs?
Yes,
And what did these photographs show?
can you repeat that?
You said a friend of yours took these photographs, correct?
Yes,
Okay. And what were these photographs of?
my neck.
Okay. And those photographs you said you sent to the prosecutor, correct?
Yes,
Okay. Okay, now, do you tend to bruise easily?
not that easily.
Okay. But bruises do show on your skin, correct?
No, not unless it's, something that's really dramatic.
So these photographs, did it show anything in the photograph?
Yes, it did.
Okay. Now, when you spoke with the female officer, did she take photographs?
No, she didn't even take any photographs.
You talked to her about the incident, correct?
Yes, I did.
Okay. And did she inform you that she was recording the conversation on her body-worn camera?
No,
She did not? And during the conversation, you were describing to her the incident that happened.
Yes,
Were you standing directly in front of her?
yes, I was.
So she was able to see you, your whole body, et cetera?
Yes,
Okay. Did you, point to any of these alleged bruises or injuries that you heard?
no, because at that time, I did not know the bruises was there.
At that time, what?
I did not know that the bruises were there.
You didn't know that the bruises were there?
No.
So when did you take the, when did you have your friend take the photograph?
I had her to take the photographs when I came back from work. That's when I looked to see in the
When was
mirror.
that?
Pardon me?
When did you come back from work?
I got up at 4, so I say about, yeah, I got up at 4, so 4:05, 4:10, it only take me about 5 minutes to get up.
Okay, so she took the photographs around that time?
Yes.
Okay, but you and the officer did not talk about your bruises or anything, correct?
No, we didn't talk about the bruises.
Okay. Now, you were also, present when the officers came and they were speaking to Mr. Gray, correct?
Yes,
And at that time, Mr. Gray was adamantly maintaining his innocence, correct?
I guess.
Objection, hearsay.
Objection sustained.
Thank you, Your Honor. Okay. Okay, and then, Ms. Caldwell, so in your testimony today, are you being truthful
Yes,
that Mr. Gray told you?
yes,
Okay, and are you being truthful that you sent these photographs to the prosecutor?
yes.
And when did you send these photographs to the prosecutor?
Say, when did I send it?
Yes, because I don't have them, so I need to find these photographs.
Oh, the very next day, because, actually, she told me that Detective Upshaw was supposed to have contacted me to get them. So after Mr. Upshaw didn't contact me, I contacted her back and told her that he had not contacted me. So she asked me then to send it to her.
Do you by any chance know who this prosecutor is, a name?
I think I got it in my phone. Give me 1 second. All I know, the name was Moses. Yeah, that's the only name I knew.
Thank you very much.
You're welcome.
Okay, no further questions, thank you.
Any redirect?
Just briefly, Judge, and this is really just housekeeping. By chance, do you still have those photos in your phone?
I think I did. Let me see.
If you don't see them, we can just handle it off the record. We'll take a look, but I'm just curious. So no more questions, Judge.
Sir, can I have one moment with my client, keep asking me? Why did you choose me?
Here you go. You want to see it?
You have them? Okay.
There's no DD charge. Hold on just a second. Judge, this is
feel right. I guess I got this, he didn't realize that we had that case pending, that's why he missed everything.
It's not needed.
It's not easy.
And none from the report.
Ma'am, you may exit the courtroom.
Okay, thank you.
What is he asking for?
Are you on the first one? Where do you want?
So what did he just ask me, what do I want to say?
on behalf of the people.
Sorry. We are back on the record in the matter of People versus Najon Boyer, 210595581. This matter is legal because after going into a breakout room, it is my understanding that there was a desire to have this matter recalled. Can I have appearances again, please?
Jacob Blugers on behalf of the people.
Danielle Catteray, P77162 on behalf of Najon Boyer.
Please state your name, sir.
Najon Boyer.
Thank you. Okay. Ms. Catteray?
Yes, Mr. Boyer had expressed a concern of wanting to disqualify this court. I told him that I didn't believe he had a legal reason to do so, so now he wants me replaced also. And I'm happy to qualify myself.
Okay, so first let me say this. Mr. Boyer, it's my
I don't know who I'm
understanding.
talking to. I can't see nobody.
Oh, sorry. Well, I don't know that you'll be able to see me much better, but I didn't realize the camera was pivoted over that way. So, this is the joy of Zoom court. We are not face to face. But that being said, it's my understanding based on what Ms. Catteray said that you wish for this court to recuse itself. That's the first thing I heard. So let me tell you that your motion. Wait, I'm just trying to get it. Oh, okay. I'm sorry. I didn't know what you said. Sorry. My response to your motion to have myself recused is denied. I haven't heard a basis, number one, for which to grant such a request. And it's really not that simple of a process. I would imagine that you are discontent with the way that I ruled on your tether violation.
No, you imagine it wrong.
Okay. Without hearing a basis for why you wish this court recused, again, that motion is denied.
Okay, I understand.
Okay, and your request to have your attorney removed, I guess I would just ask is, do you feel as though there's a breakdown in your communication with your attorney such that that is?
Neither one of y'all are helping me in my case. Y'all are still holding me on this case. Y'all, I still haven't got a discovery packet or nothing. I don't even know what I'm facing. Y'all just going off allegations. Come on now.
Let me take a moment and tell you, Mr. Boyer, that my job is not to assist in your defense.
Well, can I get a discovery or something? Can I get something, some information?
What? Hold on. We're gonna come back to you at another time. You can just sit tight.
I got time.
Judge, if I may.
Wait, hold on. Yes, I'm gonna bring him back for that express purpose of releasing you.
Thank you.
Sorry. Mr. Boyer, your attorney is going to be released. We are going to work on getting you a new attorney, and we are going to put you back in the waiting room. And please, let me say this, sir.
Say what you gotta say.
When you come back into the courtroom, you need to pipe it down. I'm gonna leave that right there. You need to pipe down. Yeah, okay.
Calling parties, are you going out? I was getting ready to call your case.
No,
Call it?
No, not yet. It's gonna be a key. Not yet.
I was trying to call Randall.
Oh, sorry.
Mr. Bloomers, is that your case? Can I call
Yeah,
it?
it is mine.
Okay, I don't know what's going on.
Yeah, well, I think we should go on the record and we'll talk and figure out what we're doing.
Calling parties on Randall, case number 2159029. The people of the state of Michigan versus Jalen Jamal Randall. The defendant is charged with count 1, home invasion, first degree. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of people.
Good morning, Your Honor. Felicia Coleman, 56278, on behalf of Galen Randall.
Good morning, Jalen Randall.
Okay, we're here today for a preliminary examination. Are we proceeding to an exam?
Well, Your Honor, I'm asking for an adjournment because I do not believe discovery is complete. I don't know if the court recalls this matter was set for this date because Mr. Randall was in jail. He has been posted bond and has been out. I made a request at PCC for Mr. Randall's phone to be available and all discovery at PCC, which was, I believe, 2 or 3 weeks ago. Maybe 2 weeks ago. I hadn't received any discovery. Got it, I believe, last week or before. No, I got it in July. Got it in July. But my discovery has 4 blacked out pages. I don't know what it entails. I have not received anything on what this is. And I've not received 911 calls, and I've not received the phone that I specifically requested at PCC. I left a message. I don't know if I left it for Mr. Bloomer, because quite honestly, and I have to be quite frank, I did not recall who the prosecutor was. But just calling and stating, asking for the courtroom prosecutor, and left a message. I have not received any response back, but also I have not received anything in regards to the specific request that I made at the PCC. So I'm asking for an opportunity to have that information. Mr. Randall is out, as the court can see, and I apologize for the delay, but I would think the prosecutor would know that this is not acceptable in regards to discovery.
Mr. Bloomer?
Well, I will say this is, right here on the record, my first time hearing about the blacked out pages. It's not something I'm aware of, so I will look into that and get that fixed. As far as the phone goes, I believe that the request was really for phone records, which there weren't any phone records. We took his phone into custody, but it wasn't extracted or anything like that. So his phone is just, I think, was taken as property. I don't know if it's even being held necessarily as evidence, but there are no records as to the phone that I could provide. It's just a physical phone itself.
Just for clarification, it was not for records. I can pull records myself. I wanted specifically to have the hard phone for the text messages and other information preceding this incident. So it wasn't about records. I wanted to review Mr. Randall's phone is what my request was, have it accessible to me.
Okay, so there are some, I see in her hand, some blacked out pages. I think that certainly should be remedied if there could be an opportunity for the prosecution, defense, and spirit of cooperation to sit down and make sure that your discovery is aligned with one another. I am going to grant the motion to adjourn. Unfortunately, you should understand, Mr. Randall, that we are not going to be able to turn around your exam date next week, not even next month, because we are spilling over due to the backup with the pandemic. So can we find a November date to adjourn this?
November 15th at 11 a.m.
Thank you. And I will be contacting the court and checking regularly because I do understand how some matters get resolved.
Yes.
And so.
I will state though, if you're trying to hasten the exam date, when matters are resolved and they get bumped off of their exam docket, typically what slides in there are custodial matters. Because we just, we're really setting dates in January now. So a November date would be soon.
Thank you.
But you're right. If there's a date that if something frees up, we certainly, if you could check back every now and again, I certainly would put you in. And in fact, while we're here, is there by chance an October date, given the fact that this is a domestic? As it certainly isn't any fault of the defense that the discovery is not legible. And nor am I suggesting that it's the fault of the prosecution, as it just became something that you were aware of today, this morning, so.
There's, I guess, October 11th at 10:30.
Can you do that?
October 11th?
Yes, ma'am.
Yes.
Okay, October 11th at 10:30. You had a witness here, correct?
Yes, Judge.
All right, the bond is going to continue. Mr. Randall, please make sure that you continue to abide by the no contact provision. Not direct contact or indirect contact, no form of social media outreach, no writing, letters, text, chat, telephone, or even having anyone act on your behalf to reach out to the complaining witness. Even if the complaining witness comes to your doorstep, you are not then permitted to engage with her. Okay, thank you.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
So when your OIC contact me.
Well, okay, so the paper, I'm gonna get sorted out. Talk to the OIC and figure out if we want to do more trash on the phone.
I don't need an extra.
No, I know, but we-
Phone accessible.
Right.
But you can still let me have the phone accessible.
Yeah, I didn't even expect it. Like, let's just go
When
talk
the
to you.
first here on Clark, what was going on with Clark?
Nobody showed up.
Well, we had Mr., did the attorney show up?
I don't have no one.
Okay, I thought I saw Mr. Miller, but maybe not.
No, that's a different.
Have a blessed, safe weekend.
You too, take care. Good to see you.
Andrea's Clark, there's two Clarks, that was.
You talking about 4 o'clock, right?
When we have ready to.
Mr. Johnson, good morning to you, sir.
Good morning. How are you, Your Honor?
Good to see you. What do you have today?
I have Kawana Brooks. It's scheduled for 11 o'clock. It was a continued preliminary exam.
I see.
Brooks.
And I think she is in my waiting room, actually.
Okay, and Judge, Mr. Ryan is in the waiting room to do Mr. Boyer.
Oh,
As a
but
spot.
Mr. Boyer, okay.
As a spot.
Okay.
Well, Mr. Boyer's no longer available.
Yeah, Mr. Menken, thank you for zooming in, but
Yes.
your client, Mr. Boyer, is not even in the waiting room anymore. I had to put him there because of a little bit of excitement. And the jail has since taken him away from the Zoom camera, according to them, due to his combative nature that was continuing. So I'm assuming, is it possible for you to zoom in tomorrow? Oh, no, not tomorrow, my goodness. Don't zoom in tomorrow.
No.
Don't zoom in. Is it possible for you to zoom in on Monday?
Let me see here. I have an in-person exam on Monday morning. I don't know who it's in front of. So let me take a look here. Who am I in front of on Monday? I don't even know. Huh. I mean, I'll just be down there, and then I can probably Zoom when I'm in the hall there.
Okay, or you can come into the courtroom and he will be on Zoom. It's just, if you have a device with you though, in the event I suspect you will likely need to go into a breakout room with him. So just make sure you have a device you can use. And we'll bump this to the 9th, August 9th. And the time is going to say 8:30, but whenever during that morning time frame, whenever you can get to us, please just let us know what your time frame is when you get here so we know when to expect you.
Okay, so what I'll do is, I probably won't get to see him except if I do a breakout room, I'll have my I'll have some kind of device that I can go into a breakout room with him because I haven't been visiting at the jail.
Okay, and you know what? I also want this is Mr. Bloomers, is it correct?
It is, I'm not sure.
I need to get I need to make sure you get the discovery as a heads up, there is an exam date set for August 13th.
Oh, that's, let me see about that. And that, is that a in-person exam then?
Yes, it is. So it would be great if you could maintain that. But I know you need.
What time is it
10 a.m.
at?
10 a.m.
10? Okay, let's see.
Mr. Minnick is going to represent Mr. Boyer. Can you get discovery to him?
Absolutely. Let me write it down.
So I'll have all the discovery necessary to do it by then.
He's going to forward it to you now. Or
okay.
Today.
And just for the record, paper and video and 911 calls were all sent to Ms. Cataray, and I will send them all to you today when I get back to the office.
And you have my email, correct? Because they seem to have it wrong through the Bar Association all the time.
I believe so, but I guess that makes me a little nervous.
Yeah, just to make sure.
Go ahead.
S.A. Mencken Law at Comcast.net.
All right, got it.
Okay, so again, we'll see you Monday the 9th at sometime in the morning via Zoom or otherwise. Okay.
And then we have the in-person exams 10 a.m. I'll work it out. I have a couple of Zoom things, but I'll bring something with me so I can. I have a 10 o'clock Zoom in Wayne County Juvenile Court, but I'll do that, and then maybe we can. We're not going to. Do we start the exam exactly at 10? Do you think, or?
Yes, sir.
That's not for lawyers, is it?
Yeah, we set the August. Oh, wait.
13th.
Yeah, but no, he's gonna come in on a PCC to meet him.
Okay.
Mr. Boyer was taken back to his cell because of his combative nature.
Understood, Judge. You had me sweating for him.
No. Okay, so again, August 9th is the PCC. Live exam is still on the schedule for August 13th at 10 a.m.
All right. Well, hopefully I can fit this in because I got that other thing. All right.
Thank you so much.
Yeah. Hopefully he gets along with me.
I hope so too. Can you give me your shot? And who's handling nonsense matter?
I guess. Yeah.
Okay. Have a good day.
You too, Mr. Macon. Take care.
Mr. Upshaw's case is correct.
It's a plea.
Is it a plea? Okay. Calling party on Almond. Case number 2062474, the people of the state of Michigan versus LeBron Almond. The defendant is charged with count 1, weapons carrying concealed. Count 2, assault with a dangerous weapon, felonious assault. Count 3, weapons, felony firearm. Commission of a felony with a motor vehicle advisory. This is a preliminary exam.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Remax Proof on behalf of the people.
Good morning, Your Honor. Randall Upshaw on behalf of Mr. Almond, key number 43574.
Please state your name.
LeBron Almond.
Thank you. All right, today is the date and time set for an examination. Are we proceeding to an exam today?
No, Your Honor.
Your Honor, I believe we have come to a resolution.
Okay.
Can I just have a copy of the plea? Your Honor, as it relates to case ending in 2472, Mr. Ullman has agreed to plead guilty to possessing a firearm that's under PAC code 750.227D. That is actually a charge reduction from count 1, and people agreed to dismiss count 2 and 3.
Is that your understanding of the negotiation?
Yes, it is, Your Honor.
Okay, and Mr. Ullman, is that your understanding of the negotiation?
Yes, it is.
All right, I just need to ask you a few questions before we proceed with the plea. Do you understand the allegations against you?
Yes, ma'am.
Do you understand that you have a right to an attorney? If you couldn't afford one, one would be appointed.
Yes, ma'am.
Do you understand that you have a right to a trial?
Yes, ma'am.
Do you understand that if the matter proceeded to trial, you would be able to have your attorney process witnesses presented by the prosecution? You could even have witnesses subpoenaed to appear and testify on your behalf. And you could even testify on your own behalf if you wanted to. Do you understand that?
Yes, ma'am.
Do you understand that if you tender a plea of guilty and the court accepts that plea, even for the negotiation, that has the effect of giving up your right to a trial?
Yes, ma'am.
And is this what you want to do?
Yes, ma'am.
You understand you can't come back in 6 months or a year and say, I'd like to have my trial in that matter?
Yes, ma'am.
Okay. Has anyone promised you anything to get you to give up your right to a trial,
No, ma'am.
other than this negotiation?
No, ma'am.
Has anyone threatened you in any way?
No, ma'am.
Are you pleading guilty because you are guilty?
Yes, ma'am.
Okay. And I want you to also understand that even though I would be accepting your plea, I will not be the sentencing judge. So this matter would be, you would be given a sentencing date in the future, probably mid to late August. In the interim, you would have to avail yourself of what's called a pre-sentence investigation that I'm assuming is done virtually. It's an interview.
Okay.
And someone will ask you a number of questions. Based on your responses, they are going to generate a recommendation, a sentencing recommendation to the judge. That would be Judge Bryant. And that is a recommendation that you'll have an opportunity to review prior to sentencing along with your attorney. And obviously the judge would read it too. If there's any inaccuracies or things that were not included in the report that you think are important, certainly your attorney can bring it to the judge's attention for consideration prior to the actual sentencing. You understand that?
Yes, ma'am.
It's important for you to also understand that while I am dismissing after the plea, counts 2 and 3, at the sentencing phase, the sentencing judge does have discretion to add things if she thinks it's appropriate. The likelihood of that happening is probably minimal, but it's important for you to know of that possibility. For instance, she can add, it's not mentioned anything in here about fines and costs in terms of the negotiation. The sentencing judge can add a fine. She can add court costs. And if she reads something in that report and is satisfied that there needs to be something added into perhaps a probation, like some level of counseling, the judge has discretion to do that. You understand?
Yes, ma'am.
And if there's something that rises to the level that's so disturbing that causes your attorney to object, certainly the plea can be withdrawn if that is what you intend to do. You understand that?
Yes, ma'am.
But it's very important for me to express to you that I'm not going to be the sentencing judge, and there may be things brought into a level of probationary period that you would be required to comply with.
Okay.
And if you fail to comply with those items, it could be as simple as just not getting any new cases.
Right.
If you fail to comply, please understand that that could subject you to further consequences. Do you understand that?
Yes, ma'am.
Okay. With that being said, do you have any questions for me before I swear you in?
No, ma'am.
Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but truth?
Yes, ma'am.
Thank you. Madam Prosecutor?
Your Honor, if I may,
Oh, yes, you can, certainly.
Mr. Alm, on December the 10th, 2020, were you within the city of Detroit?
Yes, yes, sir.
Were you in a motor vehicle?
Yes, sir.
Did you have your registered weapon with you?
Yes, sir.
Did you have a permit to carry a weapon in that particular manner inside of your vehicle?
Yes, sir.
No.
No, sir.
You did not have a CPL, correct?
No, sir.
And you was unlawfully or wrongfully carrying that weapon in the interior of the vehicle, correct?
Yes, sir.
Now,
Madam Prosecutor, are you satisfied?
People are satisfied here.
Court is likewise satisfied that your plea is knowingly and voluntarily given, and accept your plea to count 1, transporting or possessing firearm in a motor vehicle, which is a 90-day maximum misdemeanor. And in furtherance of the negotiation, counts 2 and 3 are going to be dismissed I'm going to need, Madam Prosecutor, your signature on the order of dismissal as you're the moving party for this negotiation, and sentencing date.
Sorry. September 17th at 9 a.m. in front of Judge Bryant.
I'm sorry, what's the,
Judge Bryant.
Brian.
Okay, you're going to get some paperwork, Mr. Ullman, in just a moment, regarding the 2 felonies that were dismissed. That will be brought to you in the hallway in just a moment, okay?
Okay, you want me to step out?
Oh, yes,
Okay, thank you.
you're welcome.
Thank you, Judge.
Good luck to you.
Thank you too. Stay corona free, and if you didn't get
I
the
know.
vaccine shot, get one.
You, listen, you too, be careful out there.
All right, you too, thank you.
Want to sign something? Oh, okay. Where's Mr. Williams at? I think this is a dismissal.
This is for Madam Prosecutor. Here you go.
Thank you.
Oh, Andrea.
Ms. Farkas?
Good morning.
Good morning.
Mr. Robinson should be in the waiting room.
Okay.
I believe the APA is Mr. Slusky.
You said that, what's your client's name?
Cordero Robinson.
At 11:30.
He took.
What is your name, sir?
Cordero Chester Robinson.
I'm sorry.
I'm sorry?
Cordero Chester Robinson.
Thank you.
I'm gonna call this one. See why witnesses hired on this case. No witnesses? We need to check with you. What's this gonna be? Okay, I'm gonna call this Cordero. Yeah, we're gonna put it up here.
You did.
Ms. Shafuki, are there witnesses on Robinson, Cordero Robinson? That's a Mr. Slusky matter, but I don't know who's covering for him.
I think you are talking to yourself.
I think so too. Okay, what? Sorry, I do that quite.
Oh, shit.
Okay.
Ms. Robinson.
Okay, that was
Ms. Farkas?
a waiver.
Yes.
I'm gonna show you. I'm gonna pivot the camera. This is the joy of what is it called, technology?
Technology, I guess.
When it works?
Yeah, it's gonna be a waiver, but we don't have a prosecutor.
Okay, officers, can you raise your hands?
I see them, Judge.
Two officers here. Are you waiving?
Yes, Judge.
Okay. Okay, officers, if you wouldn't mind, if you could stay in here until the waiver's placed on the record. Thank you. Can we call?
I have to find a prosecutor. It's
Oh.
Mr. Cook, and he hasn't even checked in.
Oh, I'm certain one of these fine prosecutors would stand in for a waiver.
No, not really.
I'll do it.
Yeah, I can do that. I'm up here already.
Calling parties on Robinson, case number 2155006. The people of the state of Michigan versus Cordero Robinson. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Jacob Bloomers on behalf of the people, standing in for the attorney of record.
And good morning, Your Honor. Neighborhood Defender Service by Stephanie Farkas, P74227, appearing on behalf of Mr. Robinson, who's present via Zoom. Mr. Robinson, please state your name for the record.
Cordero Robinson.
Thank you. Madam Defense?
Your Honor, I have advised Mr. Robinson of his right to have a preliminary examination in this case, in which the people would have to establish by probable cause that he's the individual to have committed the alleged offense. Having been advised of that, Your Honor, Mr. Robinson would like to waive his right to have a preliminary examination in this case and be bound over to circuit court.
Mr. Robinson? Can you hear me?
Yes.
Do
Yes.
you understand the allegations against you, sir?
Yes.
Do you understand you have a right to a preliminary examination?
Yes.
Do you understand if an examination occurred, the prosecutor would need to establish by probable cause standard crimes were committed, city of Detroit, county of Wayne, that you probably committed that crime?
Yes.
And if the prosecution was able to clear that hurdle, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process, sir?
Yes, ma'am.
So the representation has been made that you wish to waive, to give up your right to preliminary examination. Is that true?
Yes.
And do you understand that that would mean that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an exam at this phase?
Yes, ma'am.
And again, is that what you wish to do here?
Yes, ma'am.
Are you doing so voluntarily?
Yes, ma'am.
Thank you. I do find your waiver to be knowingly and voluntarily given. There's an examination waiver form that needs to be forwarded to you, Ms. Farkas. Then I need your signature as well as your client's signature. If he's going to give you permission to do so, that would be great and satisfactory with the court. Can you return that form to us? I see you're in your car. Are you going to be able to return that to us?
Yes, Judge, I'm actually on my way to the office. I thought I would be able to get down there beforehand, but I hit some traffic, so.
All right.
Yes, Mr. Robinson, do I have permission to sign your name to the examination waiver form?
Yes, you do.
Okay.
Thank you.
The matter is bound over to the circuit court for further proceedings with an AOI date of August 27th at 9 a.m. Thank you, officers.
Thank you, Judge. Mr. Robinson, you can sign off.
Okay.
I'm emailing this form to you, Ms. Farkas.
Okay, I'll get it to you today, Tammy.
Thank you.
Thank you.
Okay. Bloomers,
Yes.
you look ready. What are you ready for?
Well, I think Mr. Dillard and I have Andreas Clark, which is gonna be a hold.
Okay.
We have a help in part though, but we need to do judge first.
Oh, yeah. Okay. Is that your health department?
Yes.
Okay. Mr. Johnson, I'm going to bring your client in.
Thank you, Your Honor.
And what is your witness name?
My witness name is, last name Smith, Jones, Samantha Jones.
Before I call that, did you have witnesses on Clark? Mr. Blake is gonna zoom in.
No witnesses on Clark.
Okay, he's
Okay,
gonna
when we
zoom
see
in.
him, we'll call that.
Okay. Calling parties on Brooks, case number 21-56465. The people of the state of Michigan versus Kiwana Brooks. The defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Rima Cook on behalf of the people.
Good morning, Your Honor. May it please the court, Dwayne Johnson, 41842, on behalf of Kiwana Brooks, and we are willing to waive an in-person appearance and proceed by Zoom today.
Okay, please state your name, Ms. Brooks.
Kiwana Brooks.
Okay, so today is a continuation of an examination which began already. And I see that your witness, Ms. Jones, is in the Zoom gallery. I brought her from the waiting room, but okay, I think she just connected. Let's pick up where we left off then.
Well, Your Honor, where we left off is that the witness had said she identified my client by a home video. And that home video was, I thought it had been provided, but it was not provided to us. So I spoke to the prosecutor about getting us a copy of that home video because we're going to use her testimony. I think we should have a right to see that the same video that she's saying I supposedly identified my client from.
I still don't know where that leaves us though.
We need the video, Your Honor.
And so you're saying you don't have the video. The video was promised to you and you don't have it. So
I don't have it. Yes, I do not have it at this time.
We never have.
okay, so the prosecutor is saying she never had the video, but if this is something that is being referred to, is this something that you have access to or can get from?
I don't
Ms.
have
Jones?
I don't have access. I have the OIC and the officer, the arresting officer. They're actually out in the hallway. The OIC indicated that she never uploaded the video because when it was sent over from the complaining witness, it was more like of a still shot because it's one of those ring bell, the home surveillance. So it was never actually playing on her phone when it was sent over. She actually watched it with the complaining witnesses.
What about the still shot? Was that sent to Mr. Johnson?
The still shot should have been sent with the discovery packet. Mr. Johnson, did you receive that in the discovery packet?
No, I don't believe I received any still shots of my client being viewed at the home. I don't have that. But I would want the video. I mean, if this is what they're using to identify my client, I believe we should have a right to see that same video.
Okay, so what I'm gonna do is ask the prosecution and the defense to have a sidebar, if you will, and determine, or the prosecutor to talk with her officer, because we have a couple of real pressing things that we can move on right now that people are lined up for waiting on. It sounds like we need some questions answered. Number one, does the video exist? Number two, if so, can we get it to Mr. Johnson? He certainly is entitled to that if it's something that is being referred to. And if in the event that for some reason it is not available, then is the still shot something that is provided in his discovery or can be provided? So let's follow up on those items. And in the meantime, if Mr. Dillard can return back into the courtroom, because we have to shut down at 12:30. So
Mr.
time
Johnson,
is of the essence.
can I please have a number so that I can call you right now? And if you don't mind putting on YouTube.
Yeah, 248-851-9400.
Okay, so
All right, I'm gonna call you right now.
with two interpreters, so I don't know if we should do that first before we start, because there's two interpreters. It's Mr. Cleaver's case as well. I'm just throwing that out there. I don't know.
Yes.
You would like to say something?
When we go back on the record, it's important, Ms. Brooks, that your video is rolling, not just when you put your appearance on, but while your case is on the record. I'm assuming you can hear me and.
Yes, ma'am. Okay.
Thank you, and someone had asked if they can
Mr.
say
Dillard.
something. If you need to call the prosecutor, you certainly can do so, but it's not appropriate right now for you to say something. Okay, thank you. We're gonna recall this when we're ready. Thank you so much.
I think we need to call the
Good morning, Mr. Blake.
Good morning.
I need a prosecutor to come in and then we can call your matter.
All right, thank you.
You're welcome.
I guess I'll leave it up to Mr. Bloomers. I don't know. I just know we have two interpreters and we're supposed to go first.
Yeah. Good morning to you. Good morning.
Are there witnesses on your case, Mr. Higgins?
I'm sorry?
Are there witnesses on your case?
I'm not calling any witnesses, but I know some witnesses.
Oh, okay, thank you. Okay, we're looking for prosecutors.
We need Ms. Yakufi and Mr. Bloomers.
Come in,
Thank you. Mr. Bloomers.
Yeah, Mr. Bloomers, I'm not sure what's going on in either case, but we have two interpreters on this other case.
I think we got everybody. So these,
I'm just saying it's 12, we're not gonna be able to do everything.
I anticipated that already. I don't know how the court, we have two holds here. We have Mr. Clark and Mr. Chavez. I believe they both indicated they want to hold.
The matter that has two interpreters, I think, is going to trump because there are two interpreters that are here. So.
Understood.
We were trying to address, Mr. Blake had a quick matter that we were going to do, but I don't know, I think it's Ms. Yakufi.
Yeah, that she is on there. So calling parties on Chavez.
Do you want to go ahead and just get a new date for Clark now, or?
Yes, that's probably a good idea.
Calling, that's the wrong one. Calling parties on Clark, Andreas Clark. Case number 2062200. The people of the state of Michigan versus Andreas Clark. The defendant is charged with count 1, police officer assaulting, resisting, obstructing. Count 2, domestic violence. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Joseph Dillard, 37225 on behalf of Mr. Clark. Mr. Clark, state your name for the record.
Outside.
So who's sitting on? But 1 minute now.
I'm gonna grab my officer witness too while we're.
Let Mr. Dillard know what we're doing, because I don't think he knows. I think he's.
I don't know. If I guess, if I found
Andreas Clark.
Okay, thank you. Wait. Mr. Booth?
I don't know,
Is he
Judge.
talking? We're good.
Is he behind the podium? There he is.
There he is.
On behalf of the people.
Okay. All right, today's the date and time set for an examination in this matter. We, as most people who practice in this court know that we're overflowing with examinations as a result of the crescendo effect of this pandemic that has backed our system up. We try to accommodate as much as we can. Our priority is to handle custodial in custody matters first, and that's what we have been doing. We have 2 examinations that are remaining to be held. Both of them are non-custodial matters. One of them has 2 interpreters, 2 Spanish interpreters that are here, one for the defendant, one for the complaining witness. I believe that means that matter would take precedence as opposed to having the second matter wait indefinitely, only to be brought in 30 minutes, which is when we have to shut down for lunch to get a new date. I think we should select a new date now. What's the closest date we can give? Is there a witness on?
Yes, Your Honor, it's a 1 witness exam and Officer Carter is present in the courtroom.
Okay, thank you.
October 21st at 11 a.m.
Your Honor, I don't, 11 is, may work, may not work. I have a preliminary exam at 12:45. And so, but that'll be here in this courthouse, so I'll go ahead and say yes.
Okay, all right. We will plug you in for that date, and I do apologize, Mr. Dillard, and to your client. Certainly, this is not ideal. I take no pleasure in having to adjourn a matter. So we will see you on that date, October 21st, in-person examination at 11 a.m. Please make sure you continue to abide by any of the bond conditions that are in place, sir, and we will see you then, okay? All right.
Thank you, Your Honor.
Thank you. Okay, great.
Calling parties on Corinne Clark, case number 2156032. The people of the state of Michigan versus Corinne Assam Clark. The defendant is charged with count 1, weapons carried concealed. Count.
That's it.
That's all the counts. This matter is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good afternoon, Your Honor. Remax on behalf of the people.
Good afternoon, Your Honor. Wright Blake appearing on behalf of Mr. Clark, P37259.
Okay, and your client?
I'm trying to reach him right now.
Okay, as soon as you, well, hold on, he might be in the waiting room. As soon as he appears in Zoom, we will recall this.
All right, thank you.
Back on the record in the I don't know that we formally called it.
We did.
We did? Oh, I know we had paused on that, but.
Are we back on Brooks?
Do we have answers on it?
We're gonna ask for an adjournment.
Okay, back on the record, people versus Kiwana Brooks, 210-564-65. Appearances again, please.
Good afternoon, Your Honor. Remax on behalf of the people.
And may it please the court, Your Honor, Dwayne Johnson on behalf of Kiwana Brooks.
Okay, and Ms. Brooks, please state your name.
Kiwana Brooks.
Thank you. Okay, thank you for the granting me that opportunity to have both prosecution and defense have some sort of conversation about these discovery concerns. Where are we with this?
Your Honor, I spoke with the prosecutor, and I think we're going to want to adjourn it to maybe till Friday, and I think we may be able to have it resolved.
Okay. You're looking for Friday the 13th. I think that might have you kind of jammed up. If we can do a Friday, but is there perhaps a Friday in September we can adjourn this? I know that's probably a long shot, but given the fact that it's held.
Why do we need to adjourn?
Ms. Jones, please contact the Madam Prosecutor.
Yeah, Ms. Jones, I'm gonna call you after this hearing to explain
If we
everything
can
that's happening.
schedule it earlier, we'll start it earlier.
Yeah,
So,
yeah.
if we can schedule it on September 3rd at 10 a.m.
Tammy, I won't be here.
No.
No, scrap that date.
Okay.
Let me go back and, will you be here August 27th?
I'll be here the 10th, if it's a Friday.
No, that's
September.
September. Oh, I was trying to get it, you said the 1st of September, okay. All right.
September 10th?
Yeah, that works. That works for me. What time, Your Honor?
Schedule it at 10, that way it'll be a held in part and we'll start it sooner.
10 a.m. September 10th.
Okay. All right. Thank you.
Thank you, via Zoom, thank you.
Everybody have a good weekend.
You too, sir.
Thank you.
Calling parties on Chavez, case number 21-56140. The people of the state of Michigan versus Mauricio Chavez. The defendant is charged with count 1, motor vehicle unlawful driving away. Count 2, larceny in a building. Count 3, domestic violence. This is scheduled for preliminary.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Sorry. Good afternoon, Your Honor. Good afternoon to your staff. Neighborhood Defender Services by Ken Reagan, P82125 on behalf of Mr. Mauricio Chavez.
Could you state, oh, I'm sorry, let's start with the interpreters first. Could you state your name, ma'am?
Eva Hernandez, Your Honor, CAO, Spanish interpreter.
Thank you. Please raise your right hand. Do you solemnly swear or affirm to translate accurately and properly from English to Spanish, Spanish to English to the best of your ability? Thank you so much. And I think, didn't we have a second?
She's in the witness room. I don't know if you want to just do it or we call the witness.
Okay, thank you. Sir, could you please state your name? Mr. Chavez.
Mauricio Alexander Chavez Martinez.
Thank you. Are there any preliminary matters before we proceed?
None from the people, Judge.
Okay, first witness.
Your Honor, the people called Claudia Lopez.
Good morning. Could you please state your name, ma'am?
Antonia, Antonia. My last name is Vivian, Vivian.
Thank you. And can you please raise your right hand? Do you solemnly swear or affirm to translate accurately and properly from English to Spanish, Spanish to English to the best of your ability?
I do.
Thank you so much. Ma'am, could you please state your full name?
Diga su nombre completo.
Claudia Lopez Garcia.
Claudia Lopez Garcia.
Thank you. And please spell your first and last name.
Y diga las letras de tu primero y nombre y apellido.
CLAUDIA LOPES Z, perdón.
CLAUDIA LOPEZ.
Thank you. Please make your way over here. This half gate will open up towards you.
Anda ahí.
And watch your step as you step up.
Y la puerta se abre y cuidado los escalones y sentate.
Your witness wants to be settled.
Good morning, or well, good afternoon, Ms. Lopez. Can you please state your full name for the record?
Buenas tardes, señora López. Diga su nombre por la acta.
Claudia López García.
Thank you.
Claudia López Garcia.
And Ms. Lopez, on or about the date of February 24th, 2021, were you at the address of 8049 Longworth Street?
Señora López, en el día del 24 de febrero 2021, ¿usted estaba en la dirección de 8049 Longworth Street?
Sí.
Yes.
And is that address in the city of Detroit?
¿Y esa dirección está en la ciudad de Detroit?
Sí.
Yes.
Do you live at that address?
¿Usted vive en esa dirección?
Sí.
Yes.
Okay. Were you living at that address on that date?
¿Estaba viviendo en esa dirección en esa fecha?
Sí.
Yes.
Okay. And was anyone else with you at that address on that date?
¿Y alguno más estaba en esa dirección, esa ubicación, en esa fecha?
Sí.
Yes.
Who?
¿Quién?
Mi ex cuñada,
My ex-sister-in-law,
su novio
her boyfriend,
y mis hijos.
and my children.
And did something happen on that date that brings you here today?
¿Y algo pasó en esa fecha y es el motivo que estás aquí hoy?
Sí.
Yes.
And just briefly, what is that?
Y brevemente, ¿qué fue?
Una agresión por parte de mí a un esposo.
It was an act of aggression from my ex-husband.
Okay. You say your ex-husband, what is his name?
Tú decís tu ex-esposo, ¿cómo se llama él?
Mauricio Chávez Martínez.
Mauricio Chavez Martinez.
Okay. And do you see that individual here in the courtroom today?
¿Tú ves a ese individual aquí en el tribunal?
Sí.
Yes.
Okay. Can you please point to him so that the judge can see and tell us an item of clothing that he's wearing?
Entonces, ¿podés por favor apuntarlo a él así la juez lo puede ver y decir lo que tiene puesto?
¿Debo señalarlo?
You want me to signal?
Yes, point physically.
Sí, apuntalo.
Usa una camisa amarilla.
He has a yellow shirt.
Let the record show that this identified person, the defendant.
The record will so reflect identification of the
La
defendant.
acta va a reflejar que hay identificación del acusado.
So, were you and Mr. Chavez still married on that date?
¿Usted y señor Chávez estaban todavía casados en esa fecha?
Sí.
Yes.
Okay. Was he living at that address on that date?
¿Y él vivía en esa dirección, en esa fecha?
No, recientemente se había movido.
No, he had recently moved out.
Okay. So, when you are at that address, how does Mr. Chavez come to be there?
Y cuando tú estabas en esa dirección, ¿cómo es que el señor Chávez entró ahí?
Por la ventana.
He came in through the window.
Okay. Were you expecting him?
¿Y tú lo estabas esperando?
No.
No.
And what room was the window?
¿En qué cuarto fue la ventana?
En el cuarto principal, en la parte baja.
So it was the main room of the lower floor.
Okay. The ground floor?
El primer piso.
Sí.
Yes.
Okay. Did you see him come in?
¿Tú lo viste que entró?
Sí.
Yes.
Okay. So what did he do after he entered the home?
¿Y él qué hizo después que entró en la casa?
Me agredió.
He
Intentó agredirme.
He tried to assault me.
Okay. And did he have permission to be there?
¿Y él tenía permiso de estar ahí?
Tenía una orden de restricción.
No, he had a restriction order.
Okay. So you say that he assaulted you. How did he assault you?
Tú dijiste que él te agredió. ¿Cómo es que lo hizo?
Objection, Your Honor. She actually said he tried to assault her.
Objection sustained, that's what I heard too.
Fair enough. You say he tried to assault you. What did he actually do?
Tú dijiste que él probó de agredirte. ¿Qué hizo actualmente?
Se lanzó sobre mí.
He jumped on top of me.
Okay. Where were you when he jumped on top of you?
¿Y dónde estaba usted cuando él se lanzó sobre usted?
En mi cama.
I was in my bed.
Okay. What did he do after jumping on top of you?
¿Y después qué hizo después que él se lanzó sobre
Me
usted?
defendí.
I defended myself.
Okay. And how did you defend yourself?
¿Y cómo te defendiste?
Lo empujé.
I pushed him.
Okay. What happened next?
¿Y qué pasó después?
Cuando salí debajo de él me mordió en mi costado.
So when I got out from underneath him, he bit me in my side.
Okay. And after he bit you, what happened next?
Y después que te mordió, ¿qué pasó después?
Salí de la recámara y fui al segundo piso.
I left the bedroom and I went upstairs to the second floor.
Okay. And where did you go on the second floor?
¿Y a dónde fuiste en el segundo piso?
A la recámara de mi hija.
To my daughter's bedroom.
Okay. And what happened after you went to your daughter's bedroom?
¿Y qué pasó después que fuiste en el cuarto de tu hija?
Llamé a la policía.
I called the police.
Okay. What happened after you called the police?
¿Y qué pasó después que llamaste a la policía?
Mis hijos despertaron y su hermana y el novio de su hermana fue abajo.
My son woke up and his sister and her boyfriend went downstairs.
Okay. And did you remain in the bedroom?
¿Y tú te quedaste en ese cuarto?
Así es.
Okay.
Yes.
So what happened next? What did you see happen next?
¿Y después qué fue que viste que pasó próximo de eso?
Bajé, después de hacer la llamada a la policía, bajé para poder salirme de la casa.
So after I called the police, I went downstairs to try to leave the house.
Okay. And when you went downstairs, what happened?
¿Y cuando bajaste abajo, qué pasó?
Fui a mi recámara para tratar de ponerme ropa para poder salir de la casa porque estábamos en invierno. Yo andaba con poca ropa porque estaba dispuesta para dormir.
So I wanted to go back in my bedroom to get more clothes because I wanted to leave the house, but it was winter and I was only dressed for bedtime.
Okay. And so what did you do then?
¿Y después qué hiciste?
Fui a mi recámara, mis hijos estaban tras de mí.
So I went in my bedroom and my children were behind me.
Entramos a mi recámara y ellos cerraron la puerta.
So we went in the bedroom and they shut the door.
Y él empezó a tocar la puerta, a patearla para intentar abrirla.
So he was pounding on the door and kicking it to try to open it.
Okay. And did he open the door?
¿Y él abrió la puerta?
Olvidamos la ventana y él volvió a ingresar por la ventana. Yo hice una llamada a la policía en esa vez.
So we forgot about the window and he went back outside and came in through the window and that's when I called the police again.
Okay. So what happened after he came in through the window this time?
¿Y qué pasó cuando entró de la ventana esta otra vez?
Quiso agredirme nuevamente.
He tried to assault me again.
Okay. And when you say he tried to assault you, what did he do?
Entonces, cuando tú decís que probó de agredirte, ¿qué hizo?
Se quiso lanzar sobre mí nuevamente, pero mis hijos se interpusieron y yo abrí la puerta y me fui.
So he tried to jump on me again, but my children got in his way and I went out the door again.
Okay. So where did you go after going out the door?
¿Y dónde fuiste después que saliste de la puerta?
al segundo piso, nuevamente al cuarto de mi hija mayor y hice una tercera llamada a la policía.
So I went upstairs to my older daughter's bedroom again and called the police a third time.
Okay. What happened after you called the police that third time?
¿Y qué pasó después que llamaste a la policía esa tercera vez?
Transcurrieron no sé cuánto tiempo y mis hijos se quedaron abajo junto con su hermana y el novio de esta. Fue su tiempo suficiente para que él tomara mis documentos personales.
So some time passed and his sister and her boyfriend were down there, and it was enough time for him to take my documents, my personal documents.
Okay. Did you see him take your documents?
¿Tú lo viste que él agarró tus documentos?
No.
No.
Okay. When did you first notice they were missing?
¿Y cuándo notaste que faltaban?
Recientemente que la policía ya había salido de mi casa.
Right after soon after the police left my house.
And before this incident, when was the last time you saw those documents?
Y antes de este asunto, ¿cuándo fue la última vez que viste esos documentos?
Ese mismo día.
That same day.
Okay. So, what happened next?
¿Y después qué pasó?
Cuando yo estaba en el segundo piso, él tuvo tiempo suficiente para irse. So, cuando yo vi que la policía llegó, bajé.
So, while I was upstairs on the second floor, he had some sufficient time to get away, and then the police came and I came down.
Okay. And when you came down, was he there or had he left?
Y cuando tú bajaste, ¿él estaba ahí o se había ido?
No, yo no sabía si él se había ido o no, porque yo bajé al ver que la policía llegó.
So I wasn't sure if he had left or not. I just came down when the police got there.
Okay.
When the police arrived.
Now, did you notice anything else missing from the home?
¿Tú notaste que alguna otra cosa faltaba de tu hogar?
En ese momento estaba en shock. No.
At that moment, I was in shock. No.
Okay. At any point after this incident, did you notice anything missing?
Y después de este tiempo, después de un tiempo, ¿notaste que había algo más que faltaba?
Sí.
Yes.
What else was missing?
¿Y qué más faltaba?
La televisión de mi cuarto.
The TV in my room.
Okay.
El speaker de el living room, el de la sala.
Speakers in the living room.
Okay.
Y mis documentos.
And my documents.
Do you know when Mr. Chavez left the location, how he left?
Y cuando el señor Chávez se fue de esa ubicación, ¿tú sabes cómo es que él se fue?
Él se fue en su carro.
He went in his car.
Okay. He took his car?
Él se agarró el carro de él.
She's already answered that.
Sí.
Yes.
Objection overruled. And the answer?
Yes.
And is that the GMC, the silver GMC Envoy?
Sí.
And ese es el Envoy GMC color de plata.
Sí.
Yes.
And that car does not belong to you?
Y ese carro no es tuyo.
She's asked and answered that.
Objection overruled.
Objeción. Tienes que hablar. ¿Y ese carro no es tuyo?
Está en mi nombre, pero no lo compré yo.
It's in my name, but I didn't buy it.
Okay. Who is the car? Is the car registered to you?
Entonces el carro está registrado en usted?
Sí.
Yes.
Is the title of the car in your name?
¿Y el título de ese carro está en tu nombre?
Sí.
Yes.
Prior to this incident, who had possession of the car?
Y antes de este asunto, ¿quién era el dueño de este carro? ¿Quién tenía posesión de este carro?
Era el auto familiar.
It was the family car.
Okay. Was the car with you at that address or not on that day?
¿Ese carro estaba con usted en esa ubicación o no estaba ahí?
Sí.
Yes.
Okay. Prior to that day, when is the last time you know Mr. Chavez had driven the car?
Y antes de ese día, ¿cuántos más antes tú sabes que el señor Chávez condució ese vehículo, ese carro?
No sé.
I don't know.
Okay. When was the last time you had driven it?
¿Cuándo fue la última vez que usted condució ese carro?
En ese momento yo no conducía.
At that time, I was not driving.
Okay. Did Mr. Chavez have permission to drive that car?
¿Y el señor Chávez tenía permiso de manejar ese carro?
¿Permiso de quién?
Permission from who?
From you as the registered owner.
De usted, porque sos la dueña registrada.
Sí.
Yes. Okay. So, how large was the television?
¿Cuál era la medida de esa televisión?
Quizás 48 pulgadas.
48 inches, maybe?
Okay. When did you first notice it was missing?
¿Y cuándo fue la primera vez que notaste que faltaba?
Cuando la policía se fue.
When the police left.
And when, the same day?
¿El mismo día?
Sí.
Yes.
When did you first notice the speakers were missing?
¿Y cuándo notaste inicialmente que faltaban los parlantes o los bocinas?
En ese momento.
At that moment.
Okay. No more questions.
No tengo más preguntas.
Cross-examination. Cross-examination.
I'm sorry, and I will state for the record that the people are seeking to move to add a count of cultivation first degree based on the testimony.
We're going to object to that, but I'll get to that.
Vamos a tener una objeción. Y eso, queremos algo del primer grado.
Ms. Lopez,
Señora López,
you and Mr. Chavez were married for a number of years, correct?
usted y el señor Chávez fueron casados para varios años, ¿correcto?
Sí.
Yes.
And you have 3 children together, correct?
Y tienen 3 hijos juntos, ¿correcto?
Sí.
Yes.
You moved to Michigan together, correct?
Se mudaron a Michigan juntos, ¿correcto?
Sí.
Yes.
You moved to 8409 Longworth.
Y se mudaron a 8049 Longworth, ¿correcto?
Sí.
Yes.
And there you live with Mr. Chavez's sister.
Y tú ahí vivías con la hermana del señor Chávez.
And her husband.
Y el esposo de ella.
And their family, correct?
Y tu familia, ¿correcto?
Sí.
Yes.
Now, Mr. Chavez worked, correct?
Y el señor Chávez trabajaba, ¿correcto?
Sí.
Yes.
And you were the homemaker, correct?
Y tú eras amante de casa, ¿correcto?
Yo trabajaba también.
I worked also.
You worked with Mr. and Mr. Chavez worked, okay?
I'm sorry, can you repeat?
Was Mr. Chavez the primary breadwinner? Would that be fair?
Y entonces el señor Chávez era lo que traía el ingresos primario, mayor parte.
Ambos trabajábamos.
Both of us worked.
You work full time?
¿Trabajabas tiempo completo?
Sí.
Yes.
Throughout the marriage?
Durante cuando ustedes estaban casados?
Sí.
Yes.
And the items that you bought in the house were marital property, right?
Y las cosas que estaban en la casa eran propiedad de ustedes ambos casados.
Sí.
Yes.
So there were no items in the house where you said, this is mine, and she said, this is mine, right?
Entonces no habían cosas en la casa donde tú decías, esto es mío, y él decía, esto es mío, ¿correcto?
No.
No.
So everything belonged to everybody in the house. Well, belonged to both of you in the house, correct?
Entonces todo lo que estaba en la casa, ustedes eran dueños juntos de todas esas cosas, ¿correcto?
Sí.
Yes.
Okay. Now, at some point, problems arose in the marriage.
Entonces en algún punto empezaron problemas en este casamiento, ¿correcto?
Sí.
Yes.
And you moved to Indiana, correct?
Y tú te mudaste a Indiana, ¿correcto?
Sí.
Yes.
And while in Indiana, you got a, do you know what the term ex parte order means?
Y cuando tú estabas en Indiana, tenías un orden de ex parte, ¿tú sabes lo que quiere decir eso?
Orden de restricción.
So is that a restriction order?
That was an order, but he wasn't there when the order was given.
Eso fue un orden, pero él no estaba ahí cuando el orden fue registrado.
Sí.
Yes.
So you got an ex parte order of protection, correct?
Entonces tú tenías un orden de protección que era ex parte.
Sí.
And at the time, my client was still in Michigan, correct?
Y en ese tiempo mi cliente todavía estaba en Michigan, ¿correcto?
Sí.
Yes.
And he was still at 8409 Longworth,
Y
correct?
él todavía estaba en 8049 Longworth, ¿correcto?
Sí.
Yes.
At some point, you came back to Michigan, correct?
I'm sorry, can you repeat that?
At some point, afterwards, you came back to Michigan.
Entonces, en algún punto después, tú regresaste a Michigan, ¿correcto?
Sí.
Yes.
And you moved in with Mr. Chavez again, correct?
Y tú te mudaste otra vez con el señor Chávez, ¿correcto?
No.
No.
So you did move back into 8409 Longworth?
Entonces, ¿tú no te mudaste a 8049 Longworth?
Sí.
Yes.
And Mr. Chavez still lives at 8409 Longworth.
Y el señor Chávez estaba en 8049 Longworth.
No.
No.
He hadn't moved out at that time, had he?
I'm sorry, who?
He had not moved out at that time.
Él no se había mudado fuera en ese tiempo.
Eso fue lo que él y yo acordamos. Él debía moverse porque iba a regresar yo a esa casa.
He was going to move out because I was going to return to that house.
He had not moved out the house.
Pero él no se había mudado fuera de esa casa, ¿correcto?
Yo nunca lo vi allí en el momento.
I never saw him there at that moment.
He still had his clothes at the house, correct?
Él todavía tenía su ropa en esa casa, ¿correcto?
No lo sabía.
I didn't know.
He still had his personal items at the house, correct?
Él tenía sus cosas personales en esa casa, ¿correcto?
Él retiró todas las cosas de mi recámara. Él retiró todas sus cosas de mi recámara y yo no volví a verlo. Yo recientemente había movido a esa casa 3 días atrás.
So he moved all of his things out of my bedroom. All of his belongings were gone from my bedroom. He had taken all those things out 3 days before I got there.
Okay. But he still had items at the house.
Pero él tenía todavía cosas en esa casa.
Eso yo no lo sabía.
I didn't know that.
And you've already indicated you two were still married at the time, correct?
Y tú también indicaste que en ese tiempo todavía eran casados.
Así es.
Yes, that's right.
And you hadn't divided any assets. You hadn't split up any property.
Ustedes no habían dividido sus propiedades o las cosas.
No.
No.
So, Mr. Chavez still had keys to the house.
Entonces el señor Chávez todavía tenía llaves de esa casa.
No lo sabía.
I didn't know that.
Mr. Chavez, wasn't it true?
I'm not object here, based on some of her answers, it's not clear to me if the witness understands that he's asking a question when he states that's not. When she says, I didn't know that makes, to me, it sounds like she thinks maybe he's making a statement and she is reacting to the statement.
Okay, so what I will, oh, go ahead, I'm sorry.
Tengo una objeción de cómo él está indicando las preguntas. Él está diciendo cosas y ella dice que no está de acuerdo. Entonces no son preguntas y me parece que la testiga es posiblemente confundida.
I understand your concern. However, you will have an opportunity on redirect to clarify anything. We're doing the best we can with the language barrier. So your concern and objection is noted, but I think the proper remedy would be on your redirect to address those concerns and add clarification to the record.
Entiendo tu preocupación de la objeción, pero tú vas a tener otra oportunidad de hacer más preguntas cuando redirectamos. Entonces, vas a tener esa oportunidad. Entiendo que hay una dificultad con el idioma y todo.
Okay. So, he came over that day, correct?
Entonces, él vino ese día, ¿correcto?
And isn't it true he came in the house?
I'm sorry.
Y él dijo, ¿y es verdad que él entró en la casa?
Sí, por la
Yes.
ventana.
Yes, through the window.
I'm sorry.
Yes, through the window.
Isn't it true he came through the front door?
No, no es verdad que él entró de la puerta de adelante.
A mi recámara él entró por la ventana.
In my bedroom, he came in through the window.
When he first came over,
Cuando él primero vino,
isn't it true he came through the front door?
¿no es verdad que él entró por la puerta de adelante? En el principio.
No.
No.
And you got into an argument.
¿Y ustedes tuvieron un argumento?
No.
No.
And you went to the bedroom?
¿Y después fuiste a tu cuarto?
No.
No.
No further questions, Your Honor.
No tengo más preguntas. Su señoría.
Just very briefly, Judge.
Previamente,
You testified earlier that you took your documents.
tú testificaste más temprano que él agarró tus documentos.
What documents were those?
¿Qué documentos fueron?
Mi pasaporte y mi identificación de mi país.
My passport and the ID from my country.
And to your knowledge, did Mr. Chavez have keys to the house?
Y si tú sabías si el señor Chávez tenía llaves de la casa?
No.
No.
Okay. No more questions, Judge.
No tengo más preguntas.
Thank you. You may exit the courtroom.
Tú puedes salir del tribunal.
Any further witnesses for the prosecution?
No further witnesses, Your Honor.
Mr. Riggins,
No witness for the petition.
is there a motion?
Yes, Your Honor. Based on the testimony, the people would move to amend the information to add count 1, home invasion first degree, in that the testimony did establish that the defendant entered this dwelling, which was occupied, and assaulted the complaining witness. He did not live there. He did not have permission to be there. He entered through the window, more than once, actually, as the testimony stated. So the people are moving to add that charge, and I believe that the elements of it were established by the witness's testimony. As far as the count for the unlawful driving away of a vehicle, I don't believe that probable cause was established based on my voir dire of the witness, so I will not move for bind over on that count. Count 2, there was some argument from defense about whether or not some of these personal items were marital property. However, I think it's safe to say that her passport and other personal documents are not marital property, and that his taking those documents certainly is a larceny from the home. So the people would move to bind over on count 2. I think that the people have met their burden as far as probable cause, and then the count 3 is the missing.
Mr. Riggins?
Your Honor, obviously, we're going to object to any charge of home invasion. To be honest, I am unclear, based off of the language barrier, if everything got across. But I do believe that at the time, these two were still married. My client, she said he moved out the bedroom, and my client, she states that my client moved out the bedroom. However, she did not state that he had moved all his stuff out the house. In fact, she stated she did not know. It would seem to me that if he had things still in his house, he would still have access to the house. Therefore, there would be no need for him to break into the house. Therefore, I don't think there would be a breaking that would satisfy any charge of home invasion. As to the larceny, again, the television and the speaker, as she stated, were marital property. None of this stuff was ever divided between the two. He had as much right to those items as she did. As far as the passports and the paperwork goes, I think she said she did not see him take it. She doesn't know. So we're just assuming, and I don't think we can say for certain that he actually took those items.
Mr. Blue?
As far as the home invasion, I would just add, she testified about having gotten her restraining order, the ex parte order in Indiana. She testified that he was no longer living there. She testified he did not have permission to be there. She testified that, to her knowledge, he did not have keys to the home. And lastly, she testified that he came in through the window, which I think supports the idea that he was not supposed to be there and knew he wasn't supposed to be there. As far as the large media building, she, I think, established she had seen those items that day and that she noticed them missing shortly after he left. And I think that's at least enough to establish probable cause. And certainly there's a question of fact.
Thank you. I appreciate your candor with regards to count 1. I would agree that probable cause has not been met as it relates to count 1, charged in the complaint as motor vehicle unlawful driving away. So that count 1 is going to be dismissed without prejudice for insufficient evidence. Count 2, larceny in the building, it is going to be bound over. I do believe that there is, at the very least, a question of fact as it relates to not only the passport, but also the TV and or speaker that was testified at the TV and the speakers. The TV and the speakers in the living room. The TV from the bedroom, speakers in the living room. The home invasion charge, I am satisfied that it is appropriate to bind over on that as well. There certainly are questions here. There's questions of fact that need to be determined by the fact finder. But the testimony that has been presented does, I believe, rise to the level to clear that hurdle of probable cause with the statements that were provided by Ms. Lopez, coupled the entering through the window, not once, but twice, and the other testimony that was entered into by Ms. Lopez, rising to the level of, I believe, warranting adding a count. of home invasion, first degree. The misdemeanor, domestic violence, is going to travel along for the efficient administration of justice. So that would be a total of 3 counts. Count 2, larceny in a building, count 3, domestic violence, and I guess you could say count 4, home invasion, first degree, will be bound over to the circuit court for further proceedings with an AOI date of August 27th. And I've prepared the order of dismissal as it relates to count 1, the unlawful driving away. Both prosecution and the defense will get a copy of that. And I also have paperwork for both of the interpreters. I hope the second one did not leave. Okay, thank you. Was there anything further?
Nothing from the people, Judge.
Yes, Your Honor, I would like to make a new motion to remove the tether from my client. My client is indicating that the tether is causing him some discomfort on his leg. Also, my client has made every court hearing, and I have remained in constant contact with my client.
Your Honor, based, on the testimony we heard today, I would object to removal of the tether. You're talking about an individual breaking and entering into the home of the complaining witness and assaulting her, and I think that the tether is appropriate given the fact that given the relationship between them and the nature of the charges.
Okay, now that this matter has been bound over and the testimony has been quite direct with regards to the unwanted contact that resulted in these charges occurring, I think that the tether is appropriate to safeguard the safety of not only the community in general, but Ms. Lopez specifically. When there's a domestic violence case, there's oftentimes an added temptation to want to reach out to the complaining witness. I want to make sure that while this case is pending, that there is no violation, and oftentimes the GPS tether is a very strong deterrent from any contact that might be tempted to have. Again, the arraignment is on the 27th, and certainly your attorney can make that argument before the circuit court, the arraigning judge. And if that judge in their wisdom deems it's appropriate, then so be it. Oh, we will need the MCL number, if you could provide that to Madam Clerk with regards to the added count of home invasion.
Yes, I'll get that back over to her.
And I'm handing this up to you so that they can go get a copy of the dismissal. Wait, did I write on there count 1? I think I did on the order of dismissal. You did. Mr. Blake never came back. Maybe he's gonna come back this afternoon. Did he send you a message maybe? We were waiting for his client to zoom
I
in.
haven't seen anything.
I think it was gonna be a dismissal, wasn't it?
If he could get his client back.
And his client never came. Ms. Yafufi, that was your matter?
Yes, the
Yeah,
court.
Mr. Blake did not return. He left out of the Zoom gallery and did not return. Can you check back with us just by way of Zoom at 1:30?
Wait.
Or 1:45, 1:45, actually. Yes, the court will stand in recess until 1:45, where we will pick up with the Kegler homicide. Hi, Miss Yafufi.
Hello.
Mr. Blake is walking in.
Okay.
No, somebody made it. I bought it at the thrift store. He was here.
Right, that's funny. That can apply to so
much,
many things
so much.
that happen. This,
Exactly.
yes, environment. That was a good one.
Mr. Blake is in courtroom 234.
Oh,
Okay.
okay.
I think he has a case there. I don't know if they've started the.
Ew, well. You're, is it Mr. Clark?
Yes.
Okay, we're just waiting on Mr. Blake.
All right.
Hopefully he'll come back in. We've got,
Let me see if my
Okay.
voicemail says something, but
You should have a message from.
you gotta hop on over onto Jefferson and it's a straight shot down here.
I'm
how
Canadian.
far away did?
She said she didn't know when she would be.
Yeah. I mean, it's down there right where I live. It takes me 23 minutes to get to work. And if there's a backup on 75, you gotta hop off.
I'm just the messenger.
Wait, so is the defendant here?
Miss Catter's client, yes.
She's okay. She's just hung in traffic.
Wait, who are you saying that to? Me? Tammy, were you talking to me?
Yeah.
No, I was saying, is the defendant here?
Yes.
He said that there, yes, I didn't see him.
Is your witness here?
I have witnesses.
The witness that you wanted?
No.
Okay, I'm gonna run downstairs and pick up the file. Here is Mr. Blake, in case he.
Okay.
Comes back.
People versus Corinne Clark, 21056032201. The defendant is charged with count 1, weapons carrying concealed, count 2, weapons carrying concealed, count 3, weapons, firearms, possession by felon, count 4, weapons, felony, firearm, defendant's listed as an habitual offender. Third offense notice today was the date and time scheduled for an examination. Mr. Blake tried to zoom in before the end of the morning, and we asked you to come back as, I need your client here.
Yes.
In order for there to be any sort of a motion that would be made. Appearances, please.
Good afternoon, Your Honor. Rima Afifi on behalf of the people.
Good afternoon, Your Honor. Wright Blake appearing on behalf of Mr. Clark, P. 37259.
Thank you. And your name, sir?
Aaron Clark.
Thank you. Madam Prosecutor, did you have any witnesses that showed up on People versus Clark?
Your Honor, I did not have any witnesses. I had just one police officer, Walden, and he did not show up. But I just want to make clear, this was a co-defendant case, and Mr. Clark was only charged with the CCW. The other charges apply to the other defendant.
Thank you, Madam Prosecutor. I am sorry, Mr. Clark. I am sorry. Yes, that is, I stand corrected. Count 1, weapons carrying concealed, is the only count that applied to Mr. Clark. With the representation that's been made by Madam Prosecutor, is there a motion?
Yes, Your Honor, we would move to dismiss.
That motion is granted. The matter is dismissed without prejudice. I just need your signature on this order of dismissal to make it official. And with that, we are all set. Matter is dismissed without prejudice.
Thank you, Your Honor.
And just so, could I show you the hand that's done? Thank you. What that means, dismissal without prejudice, is that it is possible it can be reissued.
Okay.
Certainly speak to your attorney if you have any questions regarding the fullness of that concept, okay? Oh, do you have on a GPS tether? Do you have on a GPS tether that needs to be removed?
No.
Okay. All right, we're all set. Matter's dismissed.
Thank you.
Are you holding an exam next door?
No, that was dismissed too, Judge.
Oh, good day for you.
Now that I deserve a break. Thank you, Judge.
Thank you, take care.
You too, thank
Yep,
you.
have a good weekend.
Likewise.
I'm sorry, we were muted. It is now 2:20, which is frustrating because this is now almost 1 hour past the time for which we were supposed to pick back up rather with this examination. It is my understanding that there was a message that was relayed to Madam Clerk regarding defense counsel being caught in traffic. Certainly that's an unforeseen circumstance. So let's try to make as good of use of our time here today as we can. What we can't get through, we will simply find a new date for. Let's pick up where we left off. The Detective Williams, I believe you were on the witness stand.
Good afternoon.
Good afternoon. Keep in mind you are still under oath. Detective Williams, and just so we can have a freshness of the record since it's a separate date, can I trouble you to state your name for Madam Court Reporter and the spelling of same?
Douglas Williams, Douglas, Williams, Williams.
Thank you. Since she's talking, we might as well, can you raise your right hand? Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
I have no other questions for him.
Nothing further, Judge.
Okay. Thank you.
Thank you.
And Judge, at this time, if people would call Corporal Tonti, who's in the hallway.
Good afternoon. How are you, sir?
Good morning, Your Honor, or good afternoon.
Could you please state your full name and spell your first and last name for Madam Court Reporter?
Jason, Jasontonti.
Thank you. And could you please raise your right hand? Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Thank you, sir. If you make your way over here, this little half gate will open up towards you. Watch your step as you come up. Once he's settled, you may proceed.
You should say your full name for the record one more time.
Officer Jason Tonti,
How are you employed, sir?
Detroit Police Department, 6th Precinct,
How long have you been with the Detroit Police Department?
25 years.
How long have you been at the 6th Precinct?
Since 2004, almost.
And what is your current position within the 6th Precinct Detroit Police Department?
I'm a traffic enforcement officer. I do all the tickets and fatal accident scenes.
And does that include responding to scenes when dispatched to a scene?
Yes,
I want to take your attention back to December 17th, 2020. Were you working that day?
I was.
Who were you working with, if anyone?
I was by myself.
And how were you getting around? In a car, on foot, or something else?
I'm in a car vehicle.
Was that a fully marked, what would be called a fully marked scout car?
It is.
All right. Did you have occasion on that day to go to 8327 Penrod in the city of Detroit, Wayne County?
I did.
And why did you go there, sir?
Run came out that there was a shooting.
And did you respond to that scene?
I did.
When you arrived to that scene, was any other officers there?
No, sir.
Were there any other medical personnel, ambulance, firefighters there?
No, sir.
So you were first on scene?
Yes, sir.
All right. When you get to the scene, tell me what you did. Did you get out of your car?
I did.
Take me through, beginning with you getting out of your car, what you see and what you do.
I exited my scout. I walked up to the location. The door was open. I was met by a female who was obviously very upset and crying. I tried to find out what was going on. She said there's a shooting, somebody got shot, and got shot.
Object to the hearsay.
Let me back up and lay some foundation, Judge, if I may. So you said this woman, this female was upset?
Yes, she was.
Tell me more about that.
Well, she was crying, and when I got up to the front porch, I walked inside the house. I went to the back of the house on would have been the northwest corner of the home, a bedroom.
Okay, let me stop you right there. You said that she was crying. Was her voice raised?
Yes, she was crying. She was
Really
upset.
Like verbally crying? Was she screaming?
Yeah, screaming, crying.
Okay, and eventually, did you go into the house?
I did.
And did you see what you said? You went to the back room.
I did.
And what did you see in that room?
There was a young boy, very young in age, approximately 5 or 6 years of age. He was seated on the ground, right in the just inside the doorway.
So let me stop you right there. You said he was seated on the ground just inside the doorway. Was he leaning up against something?
No, he was slouched. He was sitting almost in an Indian position. You know, you sit like an Indian position, legs crossed.
Okay.
And he was slumped over.
Okay.
And he had a large amount of blood coming from his head.
Did you observe any injuries to him?
I did.
Where were those injuries on him?
The head.
And with what you saw, the injury to his head, is that consistent with something that you've seen before?
Yes, sir.
What was it consistent with?
A gunshot.
Okay. Now I want to go back to when you got to the door and you saw this female. What did she tell you?
Objection to hearsay.
Because I think the foundation for an excited utterance has been adequately laid at this point.
Objection overruled.
What did she say?
Well, I didn't really talk to her. When I got to the location, I called for another car.
Actually, I'm sorry. Doesn't the witness have to be unavailable for that to come in as an excited utterance?
No, Judge.
Objection is overruled.
To the best of your memory, what did this woman say?
She was just she was very upset, crying, very loud. She was obviously very upset.
Okay. Do you remember anything specific that she said while she was upset?
I do not.
Okay. Now, you said you went to this back room where you saw a young child. Could you describe to the court more about this, what you saw back there?
Oh, it was early morning when I got there, so it was the child was in, I believe, if I remember correctly, it was like a blue shorts and a shirt. He was slumped over forward, again, with a large amount of blood coming from his head.
Okay, could you tell if the child was alive?
No, I'm not a doctor, but he didn't appear to be alive.
Okay. And do you remember what else was in this room where the child was?
There was to the right, when you walk into the door to the right, there was a desk or something there, and not much else.
And you said you called for other units?
I called for an EMS, and I was trying to get the EMS there quicker. I know it was a bad storm that day. There was a lot of snow on the ground, so.
Okay. And when you were in the room, you said it was consistent, the injury was consistent with a gunshot. Did you see a gun in the room?
I did not.
Now, did EMS or firefighters eventually arrive?
Yeah, after about 2 to 3 minutes, Detroit Fire Department pulled up, and they were assisting the child where they were getting his head wrapped up and getting him moved out, getting ready for EMS, who showed up shortly after.
Okay, and did you observe the firefighters or Detroit Fire assisting the child?
They did. They did a very good job, actually.
Did you observe it, though?
I did.
Okay. You said the EMTs, did you say EMTs arrived as well?
Yeah, just shortly after Detroit Fire pulled up.
Okay,
EMS.
You said shortly after, approximately how long?
2 to 3 minutes.
All right. Now, what time did you arrive, if you remember?
Well, I was the first car on scene. I was right down the street, so it was right after the police run came out. It was less than a minute.
Okay. Did anybody remove the child from the home?
Detroit Fire Department and medics and Detroit Fire did remove the child.
We have one moment, Judge?
Yes.
Approximately how long were you on the scene?
From start to finish, a couple hours.
Okay. The woman that we spoke about earlier who was upset, when all of these did other officers arrive?
Yes, Officer Knapp, who was working with me, he arrived shortly after.
Okay. And other officers as well, if you don't remember the names, that's fine.
I don't remember the names, but other officers showed up as well, yes.
Okay. And during this time when EMS, Detroit Fire, and other police officers are arriving, is this woman still upset?
She is.
Was she upset for some time?
The entire time I was in that room, she was.
Okay. How long were you in the room for, if you can remember?
I would say about 5 to 10 minutes, maybe less.
I mean, I'm gonna object to the OIC going out in the hallway. I don't know if he's going out to talk to other witnesses. There is a sequestration order. I'm concerned about where he's going. So.
Judge.
Okay, well, certainly witnesses or officers, if they're the officer in charge, are not mandated to remain in the courtroom at all times. However, since the inquiry has been raised, if you could please have Detective Williams come back inside and answer those questions. If you could ask him, Mr. Makepeace, that would probably be great.
Sure, Judge. Detective, who was previously placed under oath earlier today, for the record, Detective Williams, why did you step outside?
One of the supervisors called me trying to locate a person and just got notified that we had a homicide.
There was a concern raised by Madam Defense that you might be violating the sequestration order. As I've indicated before, I'm going to state again that any OIC that is permitted to remain in the courtroom is not mandated to stay in the courtroom, as certainly there may be other things that arise that necessitate an officer to leave the actual courtroom. However, since the concern has been raised by Madam Defense Counsel, I'm glad that you were able to respond to the queries. Again, the concern was that there was a violation of the sequestration or a possible potential violation of sequestration, and I think we've adequately addressed it.
Yes, ma'am.
Madam Defense, did you wish to voir dire Detective Williams any further?
No, I'm satisfied.
Thank you.
I have nothing further, Judge.
Cross-examination?
I just have a few questions. While you were at the residence on Penrod, did you go upstairs at all?
I did not, ma'am.
Did you see people, other officers going upstairs?
I did not.
Okay, no other questions.
Nothing further, Judge.
Thank you. Thank you, Officer.
Thank you.
Next witness.
Judge, at this time, the people call Corporal Knapp. Would you send him in, officer? Yes, sir. Thank you. Step right up to the podium.
Good afternoon, sir.
Good afternoon, Your Honor.
Could I trouble you to state your full name and spell your first and last name?
Corporal Paul, Paul, Knapp, Knapp, Detroit Police Department.
Thank you. Could you please raise your right hand? Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth?
I do.
Thank you. If you make your way over here, this half gate will open up towards you. Watch your step coming up. And once he's settled, you may proceed. You may proceed.
Thank you. Could you say your full name for the record one more time?
Paul Knapp.
And what do you do for a living, sir?
Detroit police officer.
And officer, I just as you were stepping up there, I heard a radio go off. Could you just turn that?
It's off.
Okay, perfect. Thank you. How long have you been with the Detroit Police?
Be 8 years in November.
And are you currently assigned to a specific unit or precinct within the department?
The 6th precinct.
How long have you been with the 6th precinct?
My entire career.
All 8 years?
Yes.
Okay. Now, I want to take your attention back to December 17th, 2020. Were you working that day?
Yes.
What were you doing? What was your role that day?
6 Motor 1. I was a motor unit.
Okay. Does that mean you were on patrol?
Yes.
More or less? Okay. Did you have occasion to go to 8327 Penrod?
Yes.
And is that in the city of Detroit, Wayne County?
Yes.
Who were you working with, if anyone?
I was by myself. I'm a single man unit.
All right. And what were you driving that day?
Yes.
What were you driving?
Fully marked scout car.
And were you wearing a full
uniform? Yes.
Full uniform? Okay. Now, at some point when you get to the Penrod address, do you get out of your car?
I do.
I want you to take me through what you see and what you do after you exit your vehicle.
Snowing. There was no steps on the porch. I jumped up onto the porch. I saw a gun near the front entry doorway. I heard screaming coming from inside of the house. Officer Tani and the Detroit Fire Department were right there with me. We made entry into the house.
Could you please, before there's an objection, could I trouble you to confine your answers to the singular?
Yes, ma'am.
Thank
Yes.
you.
So just talk about what you did and what you saw. Going back, you said that you saw a gun.
Yes.
Tell me about where that gun was.
It was black and silver semi-automatic handgun. It was on the porch to the right of the doorway, front entry doorway.
Okay, and when you saw it, at any point during your time on the scene, did you touch or remove that handgun?
I did not.
Okay. Did you inspect it at all?
I did not.
Is it your job to do any of that?
No.
Okay. You said you proceeded into the house. Could you describe the house for me, what you saw when you went inside?
This house was a 2-story home. The living room, you walked into the living room, which adjoined the dining room. And then to the right, there was 1 bedroom along with a hallway.
Okay, and did you proceed into any of the other rooms past the front room?
I did for 1 split second. I went to the room where the child was laying on the ground.
Okay, and when you went to that room, did you see a child laying on the ground?
I did.
And was there anybody attending to him at that time?
Yes.
Who was attending to him?
Detroit Fire Department.
And did you see what they were doing?
No, I did not. There was just too many.
Okay. Did you see anything else inside of that room?
Just blood on the floor.
Okay. Do you remember what else was in the room in terms of objects or what?
Not at that particular time.
Okay. At some point, do you see what else is in that room?
Yes.
Okay. What else was in that room, if you can remember?
It looked like a homeschooling room. There was whiteboards on the wall. A chalkboard was on the wall, and there were books.
All right. Was there any desks?
Yes.
Okay. Now, when you arrived, you said that there was EMS was already, or firefighters were already there?
Yes.
Was there any adult that was not law enforcement or medical personnel there?
Yes.
When did you first encounter her? Or let me lay a foundation. Was it a male or female?
Female.
When did you first encounter her?
when I walked into the house.
Okay, and could you describe how was she acting? What was her demeanor?
Hysterical, absolutely hysterical.
And I noticed you put a little emphasis on the word hysterical. Why did you do that?
Because she was yelling, she was screaming, she was crying. She was walking around the house. She looked like she was lost.
Okay, and was she saying anything? If you can remember.
At that particular time, she was on the phone saying, he shot himself, he shot himself.
Okay. Now, let me ask you this. Were you wearing a body-worn camera that day?
I was.
Okay. And did you have, before testifying today, did you have a chance to review that body-worn camera?
I did.
Excuse me, Judge. Without going into too much detail, does that body-worn camera that you reviewed fairly and accurately depict what you observed, or at least from your camera's point of view, what was going on in the room and house that day?
Yes.
And how long was that video that you watched?
19 minutes.
Okay. And during the 19 minutes, is this female's actions and demeanor captured on your body-worn camera for at least some of the time?
Yes.
And during those 19 minutes, was she acting hysterical like you described?
Yes.
For the entire 19 minutes?
She calmed down at one point, but then for maybe 2 or 3 minutes, enough to get her name, and then she began to scream and cry again.
Okay. May I approach, Judge?
Yes.
Approach. Because that's the portion of it. It's 2 hours long.
It's almost 3 hours long. I don't remember the first 18 minutes.
Yeah, absolutely.
So I'm going to object to the entry of the video because there's statements on here, several statements on here by the woman that was there, but they weren't from her personal knowledge. So their hearsay that she's saying, and now it's being added in here, is for the truth of the matter asserted. So that's my objection.
Mr. Makepeace?
Judge, certainly the people are admitting this for that woman's statements. I believe there has been a sufficient foundation laid, not just from this officer, but the previous officer that testified, that they are an excited utterance. And with respect to the video itself, this officer testified that for the entire video of 19 minutes that he watched and reviewed before, that she was excited and hysterical, putting an emphasis on hysterical. I believe with respect to defense counsel's argument of personal knowledge, from the video and from the Officer Tonti who responded, she was in the home at the time this happened. There was an exciting event. Officer Tonti went into the home and saw a child suffering from a gunshot wound. That's the first requirement, that there be an exciting event, and the statements have to be within the witness's personal knowledge, or the declarant's personal knowledge, sorry, and they certainly are. She was in the home when it happened. So I think that the video is admissible under the hearsay exception of an excited utterance based on the foundation that's been laid between the witnesses today.
So if I could respond. The excited utterance doesn't last the entire time the police are there. The excited utterance is only when the initial excitement occurred. So outside of the first few minutes of the officers being there, whatever would have came out of her mouth would have been considered an excited utterance, but the officers questioning her and her answers to those questions are not excited utterances. And they're asking her the story instead of asking the children, who they were prohibited from asking questions to. So I believe everyone in the room knows, I mean, besides the court, that this woman was not anywhere near where this shooting occurred. So everything that she's saying is either from a child, a small child, or it's her assumption. So it's not an excited utterance, though, if they're questioning her and she's responding.
Okay, so just so that there's full transparency on the record, I have no idea what's going to be depicted here. Both prosecution and defense are far more intimate with what is depicted in those images or in the video. So your response to that?
Judge, defense counsel is correct that the contents of the statement must have been within, which is the entire video, and I'm going to respond to the time element of this as well. But first, that it must be within the declarant's personal knowledge. The personal knowledge doesn't mean she has to be an eyewitness. She was in the home when it happened. She would, she said that she heard something and continues on about what she knows about. And personal knowledge can be, or personal observations can be with your eyes, with your ears, with other senses. It's certainly within her personal knowledge. It's a common sense inference that if she was in the home when a gun was fired, she would have personal knowledge of that, whether she actually saw it with her eyes or not.
My concern is not so much with that aspect of the argument raised by defense, but Madam Defense's objection with regards to these are questions and answers provided in a question-answer format, which again, I have no idea what's depicted on the video. Your response to that?
Judge, I can certainly provide the court with case law if you give me a moment, but in my review of the case law, just because it is in a question and answer format does not preclude its admission under the excited utterance. It is certainly a factor for the court to take into consideration at this point. However, it's not dispositive on the issue of whether it's admitted. Some of the statements that she makes are in response to questions. Some of them are not. Some of them are when she's on the phone with someone else and telling that person what happened. So ultimately, the question is whether the witness was under the excitement caused by the exciting event. If the court were to watch the video, and Your Honor is certainly allowed to take that into consideration with all the other foundational evidence that's been admitted at this point, to determine whether it is an excited utterance, as long as the statements were made under the excitement caused by the event, they are admissible. Whether they are in response to a question is just one factor among many to take into consideration.
I also want to include that the officers were not allowing her to leave. She was forced to stay there in that room for 3 hours, subjected to the repeated questioning over and over by these officers. So it's not like she could even escape them. I think it's outside of the case law that the prosecutor is I don't know, he hasn't cited anything, so I'm guessing that he's read, but I don't believe that that's true. It doesn't go on forever. She was basically being detained because she wasn't allowed to leave the house. And although she wasn't handcuffed, she essentially could not leave. They were getting upset with her for even going in the bath where her children were. So it's an issue.
Okay, so again, these are concerns that are outside of my knowledge base because we haven't quite gotten that far, but your response to that?
Well, Judge, I guess I'm a little confused because I agree with defense counsel in the sense that the excitement doesn't last forever. But certainly that's why the people are only admitting the first 19 minutes of this. Secondly, with respect to her ability to leave or not, I mean, is this a Miranda issue that we're talking about? Because the defense doesn't
Honestly,
understand.
I don't know because I have not seen the video, nor was I present. I'm just listening to what the what the arguments are being raised by defense counsel.
Well, Judge, my argument to her ability to leave or not would be that this defendant doesn't have standing, as they would in a Fourth Amendment argument. They don't have standing to raise that issue. It's her constitutional right, but we're not really talking about that. At no point was she placed under arrest, and certainly the first 19 minutes of it is after a gunshot was fired. She was excited. That's been established. She made statements. The people are attempting to admit those statements under the 803 exception of an excited utterance.
I don't know if you were standing up to say something? Or?
Yeah, so, I mean, it's not a Miranda issue, I'm talking about the reliability of what her statements were.
Okay, the objection is overruled. I think a proper foundation has been laid. I am going to allow its admission. I don't know if you have something that you're prepared to play right now. The court will give it the appropriate weight as is warranted. I have enabled the share screen if that is something that you were prepared to play right now.
Yes, Judge.
The objections are noted, but this court is satisfied that the statements thus far with the testimony that has been elicited by the prosecutor, that the statements were excited utterances. The foundation has been laid not only by Corporal Knapp, but also by the previous Officer Tonti, who testified as well. So please, if you could.
And Judge, if I just may lay the foundation for the actual physical exhibit.
Okay, and let me also say this, you're free to voir dire, Madam Defense, if you'd like on any issue prior to the court, this being published, but.
Yeah, I would like that opportunity.
Okay, would you like to do that now?
No, I'd like, the foundation to be laid and then for, actually, I'd like to just wait to do that after, the prosecutor is done, so if he could wait to publish until I'm done with cross, then I would be satisfied.
Well, Judge, I would ask the court for permission to publish. That's ultimately up to you.
Yeah, if your intention is to voir dire with regards to the showing of that prior to it, then I think it's appropriate after the foundation has been laid, then to toss it to you to see if you'd like to voir dire. If not, I am going to allow prosecution to publish.
Thank you, Judge. Judge, may I
Provided a
approach?
foundation is laid.
May I approach?
Yes.
I'm approaching with People's Proposed Exhibit 9. Can you take a look at that? Have you seen that disc before?
Yes.
And do you know what's on that disc?
Yes.
What's on that disc?
My body cam footage from that day.
And is that what you reviewed today?
Yes.
And does that fairly and accurately depict your body cam footage from that day?
Yes.
Thank you. Move to admit People's Proposed Exhibit 9, Your Honor.
Over Madam Defense's objection, it will be admitted as People's 9.
And permission to publish, unless there's one.
Yes, did you want to voir dire?
Yes. There were several officers in that house at that point, right?
Yes.
And the person we're talking about is Tira Kegler, correct?
Yes.
And Ms. Kegler was not allowed to leave that house, was she?
No, she was not.
So there were other people, other family members that were trying to come inside the house. They were also not allowed to come in, correct?
Yes.
And there were how many children? 5 children in the back of the house?
5, yes.
And she was not allowed to go stay in the back with them, correct?
No, she walked back there quite a few times with me to just keep them calm.
So she was only allowed to go there with the kids just to keep them calm, right?
Let them watch movies, yes.
Do you know if Ms. Kegler felt like she was in trouble for
Objection
what happened?
Objection sustained.
Can you tell me how Ms. Kegler reacted when she was repeatedly told that she couldn't leave?
I have no idea how to answer that because I did not tell her she couldn't leave.
Okay. And you know that she was not
in the room when this occurred. Right.
Right, yes.
You were there when the EMTs left, right?
Yes.
And was it you that told her that the EMTs told you that he was, that the small child was still alive because his heart was still beating?
Still breathing, yes.
Okay. And to your recollection, did she feel relieved and calmed down by that?
I don't recall.
I have another. Rewind?
I'm gonna, if the court will allow.
Oh, yes, please, yes, thank you.
And again, Judge, I just have to step aside to do that.
Good. All right, step it up, step it up.
Yo! What do you got? What do you want, Tony?
I know where that weapon's at.
I got it already. I gotta stay here. All right, let's.
60F2. Yeah, it's gonna be a child, probably 5 or 6 years old. I'm gonna need a supervisor to make the corporation group.
Come home now to inside himself.
Alright, 60F2, just confirm shooting.
Come home now.
14.
Come home now. He shot himself.
Radio Connor 6-.
He shot himself with a gun playing with him.
6-. Radio. 6-. I need a supervisor to make 8327 ping rod. 8327 ping rod. There's a child at that location with a 750 gunshot wound. Need a supervisor. 14 will work on that ASAP, sir. Going at a 1018.
He shot himself.
Please on my line.
Ma'am, ma'am, ma'am.
Step on each other. What was the last minute?
He's breathing. Breathing? Okay.
Dude, going up and down. He's breathing.
Keep going
her name. Get her name because she moved the gun.
6TF1 radio. CTRM radio, ignore K-Tech. To my knowledge, no, not yet.
Ma'am, you gotta stay there. Ma'am, you gotta stay there. You gotta stay back. You gotta stay back. Move your car. Move your car.
1
minute right here, sir.
327.
Alex, still a minute out.
Whose gun? I don't know. I didn't move it. I didn't touch it. It's right here.
All right, everybody. I'm getting notes here in the CAD. It's a DOS. K-type. It's a K-type.
Is there another one?
It's not. We're just waiting for medical on location right now. ITF2. It's not as of this time. Copy that. 679. Yeah, put me around, please. Okay. I'll be signing on slowly. All right, copy. Cool.
New guy? Hey, is that a new guy?
She said, we'll try to talk to that lady real quick, right there. See, because she said that's my baby, so I don't know if that's, if it is, get her name, get the child's name.
Tom, we're ready.
All right, they're ready. They're ready. Ready.
Copy, over 2.
We got medics on scene there, Tony.
Hey, Luke, you're gonna carry him to the ring. That's Luke. Hey, it's slippery outside.
Hey, y'all block me. Get me down. Get my shoulder.
I don't know. I was in the back with the kids doing the tutoring with Ibrahim, and I come out heard a pop.
Yo!
I
I got the gun right here, Tony. I can't move.
Please, now. Please.
All right, you got to watch that gun. I'll watch it. All right. Ma'am, I know this is. What is your name?
Oh my God.
Just stay right here. Just.
TF2.
Oh my God!
And then it's fine being the whole foot. I'm going to go over there.
Why would he play with that? Why? Oh my God! Oh my God! Oh my God! Was he sleeping?
Yes. Yes. That's why. No, that's why they took him so quick.
I'm trying to talk to the police now. I'm trying to talk to them now. I was setting up the tutor for Ibrahim. I was setting up the tutor for Ibrahim, and I heard a pop. I heard a big pop. I ran out of Miriam. He shot himself. I'm like, what the fuck are you talking about? And I run and I see my nephew bleeding into the floor. He shot himself in the head. I'm not playing.
That's her son. Yep. Okay. She going to the hospital?
Right now.
She's on the, is she in the ambulance or is she in the car?
In the car, she's about to leave right now.
Okay. He got his, the name?
He got the name of the kid. She's hysterical. He can't get, you know what I'm saying? So I told her to get the plate number real quick and.
Kind of run it from there.
Yeah.
Ma'am, what's your name?
Tara Kegley.
What is it?
Tara.
How do you spell that?
TIRAH.
A-H.
K-E-G-L-E-R. What the fuck?
K-E-G-L-E-R. What's your date of birth, ma'am? Ma'am, you can't come in. Ma'am, you can't come in. You can't come in. Ma'am, you need to go to the hospital.
Your son?
That's your son. Go to the hospital. Hospital.
The baby's okay. The baby's okay. The other two, yes.
Where are they at?
They're in all in my bedroom.
Okay, okay. What's your date of birth, ma'am?
September 16, 1990.
9/16/90, and you live here? Okay. What's a good phone number for you?
313.
Yep.
Shut that door.
I will. 31. Hey.
No.
Okay, let's go back there.
No.
Impersonate larceny, Dollar Tree, 21310 Grand River.
I'm sorry, y'all. Thank you.
313.
Exit out of what you buy. Y'all just watch
Impersonate assistant secondary with 19300 21431 Grand River Meyer.
What's that? Just stay. We got
Did y'all get the gun off the porch?
we got it. Was there a magazine in there? Did you take anything out?
I didn't take nothing out.
You just grabbed the gun?
I just grabbed it off the floor and moved it.
Okay. What's a phone number for you?
313.
Yep. 434 9428.
Yes, sir. Good morning. Do you have code 4847 working today? Believe I do.
And all you heard was the one shot, ma'am?
If possible, can you have him give me a call at 313-300-2405, 313-300-2405?
One shot. And then you picked the gun up and you put it on the porch?
Code 4847.
She's inside. I'll call him on the bell.
Okay, thank you.
When we're back from the DDC, we're going to go back to the original run location for updated info for the 882.
You got her name?
Her mother.
Okay. All right, she's going to the hospital?
Well, I don't know if she left you.
Was he really breathing?
He was breathing, ma'am. That's why they hurried up and rushed him to the
Was he
hospital.
really breathing? Don't just tell me that because you want me to feel better. Was he really breathing?
How many children are in the back room?
I got 5 kids.
Are they all in the back?
Myers, do they need assistance or just a command for an
Yeah, they got an arrest. They need someone transported.
I guess I'm going to get a...
Glenn said he's coming.
Glenton?
Yeah.
Glenton's coming?
He said 679 showed me a route. That's what I heard.
Okay.
I don't know, maybe something else.
I know they're leaving I know they're working at 11, so he may have already been here. Unless he's working PDU today.
I see him pull into the garage.
Did you? What time?
Yeah, I was leaving to come here.
Okay.
radio check?
Good test.
Ma'am, where were the other children when this happened? He was by himself?
Scout 83. What's your status on Pembroke Run?
We're currently typing in notes.
Okay, will you go by Meyer and scoop up this guy that secondary
Three
told us
children
300 this out of the
in the
way.
computer room.
Uh-huh.
I have 3 children.
14.
Computer room. There's 2 upstairs.
Okay, so
He said my
2 were upstairs here?
No,
2 upstairs. My brother lives in the
Okay. Was he by himself? He did it in front of the 3 kids?
8 or B. 8-1 is going to send you a CAD message or a text message, one of the 2.
My oldest son.
Where?
And my 2-year-old. They're all in the computer room.
Okay.
My 2 older kids were doing their schoolwork. And my youngest son was in the
6 Cross Radio.
black
6
chair.
Desk.
And he was upstairs with her baby brother.
That's confirmed. 6 TF2 is en route. Follow the medics. I believe they're there now.
Thank you, sir.
Copy that.
Oh my God.
6 TF1 Radio. We have a hospital now.
All right, I'll show you there along with 2.
Hey, Bennett, you on 6? Bennett or Tani, you guys on 6? Once we need to find out the names of the children that were in the room with.
6-1, correction, 6-6.
Marcus.
Okay.
My oldest son, he's 10.
He's 10. You write that down.
Are you going to Penrod or are you clear?
We're headed to Penrod.
I know all that info. I got her name.
Okay, copy.
Yeah, 6-1. Can you check the CAD to make sure I'm seeing we're on Penrod?
6-1, I got you there on Penrod.
R.I. M.A.R.S.
You're over there with TF4.
Yes.
That's the making this location.
I will.
Yeah.
Okay.
679 is en route to Penrod. 679.
Say it one more time.
My daughter, Miriam Amar. M.A.R.I.
10:31 hours.
A.M. Last name A.M.A.R.
A.M.P.M.
M.M.A.R. 8. She's 8.
Radio 6122.
6122.
Yes, sir. Is that shooting on Plainview or Penrod?
Penrod. 8327 Penrod.
I can't get out.
Okay, you can show me en route.
Copy.
Oh my God. I'm sorry, I'm trying to be cooperative, but...
Ma'am, it's fine. You want to take a seat? You want a glass of water or something? Okay.
Give me your P number again. It's gone from the CAD.
234.
Any more weapons in the house?
No, that was the only stupid fucking weapon in the fucking house. That's the only stupid fucking weapon in the house.
8112. Out there. We got one at number 6. We got a child that shot himself.
Isa Amar. ISA. A.
Okay, 14.
Last name A-M-M-A-R.
Copy that. You're welcome.
He's two.
6 TF1 review. If any unit at that scene can get a name of this child.
All right, 6 TF4 for 6-1.
6 TF4, give me 1 second.
Okay.
You got the child's name?
The one that was conveyed, yes.
You do?
Yes.
Okay.
And the mother.
And the mother?
And the vehicle.
You got his date of birth?
No, she was.
His date of birth is
679, let me know when you're on scene.
What's up, T? I'm gonna give it to you right now. I don't mind. T, what is it?
T-E-N-N-A.
That's his first name?
Yes.
All right, his first name is
N. M-A-N.
T-E-N-M-A-N, right?
Yes.
10 man, yes. And what's his last name? What is it?
811
We're
calling.
trying, bro.
Quayle. K-W-E-L-I.
K-W-E-L-I. K-W-E-L-I.
6 miles and 5 points.
Yep.
Gray, 7 Malibu.
What's his date of birth, ma'am?
Okay.
Six.
811, give me a dispo for St. Mary's.
Just a few additional questions, officer, now that the video is played through to completion of this exhibit. A couple of questions were asked about moving the gun. Do you remember that part of the video?
Yes.
Do you remember what Ms. Kegler said to you when you asked her that question?
No, I don't remember.
Okay.
What was the question you were referring to?
I believe what Ms. Kegler stated was that.
Objection.
No, I'm sorry. I'm sorry, I'm not asking for anything that was said.
Oh, okay.
I'm asking you, what is your question to him?
My question was in reference to what was just played in the video.
Yes, you asked him. Never mind. I think the record will reflect, when you read it back, you'll understand my question.
Okay, it was probably a poorly worded question too, Judge, but the video's in, so I have nothing further.
Okay. Any cross-examination?
Yes. Do you remember being there for about 30 minutes when you realized you had not cleared the house?
Yeah, I don't know why we didn't clear it.
Okay. And then you went upstairs, correct?
I did later on, yes.
Okay. And that was maybe about 33 minutes after you had arrived, approximately. That sound right?
Yes.
Okay. When you went upstairs, you seen a black nightstand in the room?
I don't recall.
Okay, so you wouldn't recall then that the drawers of both of those in that nightstand were closed?
No,
If watching that part of the video, would that refresh your recollection?
it would, yes.
Can we play a few minutes of the?
Give me one moment, Your Honor, I have to pursue my laptop and pull that up.
Yeah. I don't need the audio if that helps you stay in the room.
Yeah, I'm just gonna show it.
Yeah, okay. Yeah,
It's not on the screen.
I think it's exactly, no, it's not on there yet. 33 minutes. I think it's maybe only, not even a minute long. That is up there.
It's carried over there, just tell me where. I don't know why this.
Yeah. No, that's all I wanted.
Okay. Judge, after reviewing the relevant portion of the video, people and Ms. Cataray would stipulate that the doors were closed when Officer Corporal Knapp went up to clear that room.
Doors of the,
Drawer, the black nightstand.
I know what you're talking about, but I want the record to be transparent of what you're talking about when you say the doors.
The drawers of the black nightstand that were previously shown in another exhibit were closed when Officer Knapp went up to the room. Correct stipulation?
That's a correct stipulation. If look and see what exhibit number it is so that there's.
Exhibit
It was
5.
like 237, I remember.
Exhibit 5.
Was it?
Yeah.
Do you remember what exhibit number it was? There's two of them I remember, of the dresser. I may have it, right here. Sorry.
It would have been exhibits 4, 5, 6, and 7 that the relevant drawer in question are depicted in.
Okay.
Okay, is that a correct stipulation?
Exhibit 4 and I think exhibit 5 are the two specific that I have written here with the dresser, the nightstand.
People would stipulate that.
Okay, this full stipulation is that the black dresser in question was, the doors of said dresser were closed when the officer entered the room.
Correct. I think maybe it's more like a nightstand, it just had the two drawers.
Okay, that stipulation is duly noted.
Either.
So are you a sergeant or an officer or?
Corporal.
Corporal, I'm sorry. So Corporal, you were there for, just under 3 hours, right?
Yes, 3 hours.
And then your job is mainly to contain the scene and to make sure like nothing happened, and so you were, for the most part, almost 3 hours standing on your feet in that living room, right?
Yes.
And so while you were there, you saw several officers come in and leave, and more come in and leave while you were there.
Yes.
And you've seen several people go upstairs and come back downstairs.
There were people that went up and down, but I don't recall if I went with them every time somebody went up there.
Okay. You can just hold on 1 second.
Tammy, do you have?
How many of those are in custody exams?
Give me just a second, I'm gonna look it up for you, Judge.
No rush on that, no rush, Tim.
Yeah. Let me see what this is. Judge, I just got Tammy. Yes. Hey. Sure, what you need? We're doing it today.
I have no further questions.
Can you read the rest?
I have nothing further.
Thank you, thank you, for that. Pass it courtroom. Your next witness?
Judge, at this time, people don't have any further witnesses for today. I'm gonna wait for Corporal Knapp to step out of the room.
Wait, hold on one moment. Okay.
Judge, at this time, the people are asking for an adjournment to another date. As the court's well aware, the people came in yesterday and requested a witness detainer for a material witness, Tyra Kegler, in this case. In talking with my officer in charge, the Detroit Police Department has been unsuccessful in locating her. Of course, they've had less than 24 hours to do so. I would ask for an additional time to give them more time to locate her and to bring her in front of this court where she could then testify as to her involvement in this case.
Okay, I would like to hear Madam Defense's response to the request for an adjournment, number one. But before that, I would like for you to lay out on the record what efforts have been made, at the very least, actually from the inception, what efforts have been made from the beginning and what efforts were made yesterday and to what success or apparently lack thereof. And if it means Detective Williams representing those statements, then so be it.
Judge, I will place on the record, and then I'm sure if I misstate anything, Detective Williams can tap me on the shoulder and let me know. First and foremost, the subpoenas requesting and ordering a court document ordering Tyra Kegler's presence were sent to Detective Williams by myself on July 20th. I believe that from that time until the date of Wednesday's August 4th exam, Detective Williams made several efforts to contact her, go to her house, last known address, to serve her with a subpoena. He either got no answer or was unable to make contact with her. That led up to yesterday, or the day before, that would have been August 3rd, when I made a phone call to the number that we had on file for Tyra Kegler. I was able to talk to Ms. Kegler. I informed her that she and her children needed to be in court on Wednesday, August 4th at 1 p.m. I informed her what the case was and why she needed to be there to testify. I received an email address from her. I confirmed the spelling of the email address twice with her over the phone. I then directly emailed her subpoenas for herself and her children to appear yesterday at 1 p.m., or not yesterday, August 4th, Wednesday at 1 p.m. She obviously failed to appear on that date when she was subpoenaed. Since then, after Wednesday's court hearing was concluded, I sent another round of subpoenas for today's date to Detective Williams. I don't know, we didn't talk about whether he attempted to serve those subpoenas, because in the interim, after speaking with my supervisors, I came back to court yesterday and asked the court to grant a material witness detainer. After placing substantially what I just placed on the record in front of this court, Your Honor granted that detainer. I then I got a miscellaneous case number, which is required, and sent that to Detective Williams. At that point, he notified an arrest team and some other officers in the Detroit Police Department to attempt to locate her. According to Detective Williams, they have been searching for her by going to known addresses, the location of the offense, but have been unable to locate her to this time. When Detective Williams stepped out earlier, he received a call from a supervisor indicating that they were still, at this time, unable to locate her. I also know this morning, Detective Williams informed me that he had gone by certain addresses associated with her based on their research into where she may be staying, and was unable to make contact with her. I just confirmed with Detective Williams that he says that all of that is correct.
Okay, I'm sorry, before you respond, as you know, Mr. Makepeace, I don't take signing a witness detainer lightly. And all of that information was relayed to the court. I did sign that witness detainer yesterday. And now, Mr. Makepeace, you come before the court requesting an adjournment from today's date to another date. And because that witness was not able to be procured. I'm concerned, notwithstanding the fact that Mr. Kegler is not in custody, I'm concerned about the indefinite period for which we would adjourn this. If this isn't a situation where it's just simply a matter of picking that individual up. There have been according to your statements here, voluminous efforts made and different addresses that you've gone to, and you don't seem to have any concrete information. So to adjourn this would be an interesting process here, because it doesn't sound like there's much solid information for which to even find this witness. But I would like to hear Madam Defense's response to the request for an adjournment. Today is the second date of the examination. We started on Wednesday, and the hope from this perspective was that we would be able to wrap up today. Madam Defense.
So, yeah, I'm gonna object to continuing on. From the statement that the prosecutor just made, I'd have to review the court rules again, since it's been since 2019 that I've subpoenaed somebody to come for a hearing outside of a police officer. That is not sufficient notice. One day is not sufficient notice, whether he called her or sent it by email. So it was insufficient notice. I don't know how he can get a witness detainer when he didn't sufficiently notice somebody. Also, he never stated anything about actually making contact with Tira Kegler to tell her that she needed to be here today. And although it's secondhand information, I was given the information that Tira Kegler actually did show up Wednesday, and I did not know that when I was here, but was not granted entry into the court building. So I've got a problem with witness detainer, especially a woman with very small children, that her kids have been through enough. This family has been through enough.
Mr. Makepeace, was she present on Wednesday?
Judge, that's the absolute first time I'm hearing of that. Certainly, if she did show up and wasn't granted entry, I would not have asked for a witness detainer. And I completely understand and have the same concerns as Ms. Hatteray. I agree she's been through a lot, and it's not my desire to throw her in jail, but not having that information. I've made several attempts myself to call her after I initially talked to her. Those phone calls went unanswered. I even attempted to call her again this morning, which also went unanswered. So it appears from my point of view and the information that Detective Williams provided to me based on this issue, that she is just being uncooperative, and she was notified the day before and was attempted to be notified in the days leading up, in the week leading up to Wednesday's August 4th date. Obviously, this is the first I'm hearing that she showed up yesterday. I don't have any information. I wasn't able to contact her to find that out either. So that's.
When you say you weren't able to contact her, you didn't have the time to, or you didn't have a working number for her?
I have a working, I'm assuming it's working because I contacted her and talked to her on that number. And I've made several calls since I contacted her and talked to her on that phone number, but she has not answered or returned any of my messages after that first contact was made, when I retrieved her email address and sent her the subpoenas. I've made efforts myself to contact her with no success.
And so if, in theory, I were to entertain your motion to adjourn, what time frame would you be looking for?
Judge, that, I understand the court's concern as well. I am available on Monday next week if we can bring her in. I'm not looking for something long. I will inform the court that after next week, I'm going on vacation for a week, which complicates things in terms of my availability. I understand that. That being said, if the court were to not grant the adjournment and leave it at that, and throw out the witness detainer, the people would be moving to bind over at this time. But I think there's necessary testimony in the form of Ms. Kegler's testimony to be placed on the record. So with that, I will leave it to the court's discretion.
With the information that I have before me right now, I'm not comfortable with granting an adjournment.
Okay, Judge, thank you.
And if I could just make a record, the reason being is that there has been a representation made by prosecution as to the efforts that were made pre-exam and in the 2 days, the day in between the start of the exam and today's date. And there's no solid information as it relates to being able to establish contact. And I know that was the point of the witness detainer, but here we are on the second day of the examination, And I don't feel confident that if I were to grant an adjournment for this specific reason, that we would be in any different position than we are right now. So I am not going to grant an adjournment. I'm not going to grant an adjournment. And I think you said you were going to be making a motion.
Yes, nonetheless, Judge, even without that testimony and our inability to get it, I would move to bind over.
Oh, I'm sorry, Ms. Catterick, did you have any witnesses you wish to present?
No.
Mr. Makepeace.
Then with that, Judge, the people would move to bind over as charged.
Ms. Catterick.
And I would reserve any argument for rebuttal unless the court has any questions about the evidence to the prosecutor.
Ms. Catterick.
Presumably, the people have met their burden, they only have some speculation about what occurred. We put forth some photos of this nightstand with drawers open. We know that the drawers were closed when Corporal Knapp first went upstairs. We're not for sure where the gun was located. We have no information about how they obtained it. We know that Tira Kegler at some point handled this gun, but we don't have nobody asked her anything about prior to the incident about where the gun was located. We only know that she knew that the gun was in the house, so there's everything's speculation. It doesn't meet a probable cause burden that my client had done anything, nor do we know if my client, well, in the video, in the interview, he states that the ammunition was all in a locked combination box. So you have to meet the gross negligence standard, and Mr. Kegler did state in the interview that the ammunition was kept separate from the gun. There was also information in there about how he had just moved in with his sister, they were all crouched into this house. So he had been checking, since they were all in that same room, constantly to make sure that this gun wasn't loaded. So if the ammunition was separated and it was in a locked container, it doesn't make sense about what happened or that how this 11-year-old obtained it. And without Tira Kegler to testify to anything that had happened, it's just all speculation. Additionally, there was, several other children in the house, so Mr. Kegler was not there. There's just too many questions. There's no gross negligence here, though. So I don't know how it could be bound over. Nor do I know how the child abuse would come through either, because there's literally no information. The only evidence that was presented was Mr. Kegler saying that it was his gun, that he kept it separate, and he kept the ammunition locked. He went through, he couldn't find the key to the combination, or the lockbox that he had it in, and then he went and took that step to go get another box through the state with the combination and had moved it there. And that the gun was kept in a, the box, I think it was the box that he bought, I can't remember exactly what he said in the interview. The gun was kept in the box that he bought the gun in, or some sort of gun box, so. Don't believe they've met their burden.
Thank you.
And Judge, with response to that, we do have what has become a somewhat circumstantial case with some dots that need to be connected. However, with respect to the manslaughter count, the first element is that the defendant caused the death of Taman Kweli. That is, that Taman died as a result of the defendant, and the charging language is placing a handgun within reach of children. In his interview, which is where we will start, he admits that the gun is his. We know from the body cam that was admitted today that there is no other guns in the house from Ms. Kegler's hearsay statement and cited utterance. In his interview, he says that he kept the ammunition in a lockbox. However, the picture that's depicted doesn't show the ammunition in a lockbox. He also states that the last time he saw the gun in the drawer, the actual handgun itself was visible and available and not in any sort of lockbox. He said that he could see that there was no magazine in the handgun. However, Judge, we can infer, and common sense very clearly indicates that one of two things happened. Taman Kweli, the defendant's son, grabbed a gun, somehow for whatever reason loaded one in the chamber, or more likely, one was left in the chamber. That means the defendant left a loaded gun available to children in that small little room that we see in Exhibit 5. And there are a few details in this room that I would like to point out. One, Anthony Johnson, the evidence tech, stated that the drawer that he recovered the magazine in, consistent with where defendant said he placed the gun last, is 2 feet high. We know that Taman Kweli was, based on the ME's report, I believe 11 years old at the time, certainly capable of retrieving that gun, as well as any other child that's able to walk, essentially, could have retrieved that gun. We know that from that, we also look at what is in Exhibit 4, which appears to be a very cramped living quarters with, there's a laptop open, there's a game controller next to the nightstand where the gun was kept. The only TV that appears to be in that room is on top of the nightstand. This is clearly where the children, or where a family was sleeping, but also where the children were playing. I believe there's even a laptop visible in Exhibit 4 that, from what I can tell, has some sort of program on it that looks similar to a Zoom conference call, indicating possibly online schooling of some sort. The children were there, the defendant's children were up there within feet of this gun for an extended period of time. The defendant also said in his interview that he observed his son, the victim in this case, watching an anime where guns were involved. He also stated in his interview, Judge, that he had, quote, heard the stories of these types of cases. So he's certainly on notice that this is a thing to watch out for when you have guns in the home. However, he stated he was careful, but not careful enough to remove the bullet from the chamber or to sufficiently separate the bullets from the gun. And Judge, that whole argument really goes into the second element, which is the grossly negligent standard that we're talking about. With respect to the child abuse counts, the first element is that the defendant is the parent of the complaining witness. Those would be the 3 children. The deceased victim, Taman, and his 2 other children, which he said were living in the home. And where there is a slight difference between these two, or between count 2 and then 3 and 4 in the language and how it's charged, because count 2 for child abuse did cause serious physical harm to a child by placing a handgun within reach of children, which is in the charging document, the information. That would relate to the deceased victim. Certainly there was physical harm caused to Taman Kweli because the ME report shows that he was, cause of death was a gunshot wound to the head and manner of death was suicide. Then, with respect to the jury instructions for that type of charge on a child abuse second, is that the defendant did some reckless act. The act here would have been placing the handgun in the drawer where any child in that room could have gotten it. And then the third element is that as a result, the complainant suffered serious physical harm, which has been established, and I don't think it's really in dispute. Going to count 3 and 4, it is a different theory of criminal liability, which is that the defendant did knowingly or intentionally commit an act likely to cause serious physical harm or mental harm to a child by placing a handgun within reach of children. And here, Judge, it's the same act, placing the handgun in the drawer, but it's likely to cause, because we don't have serious physical harm to the other 2 of defendant's children who were in the home. But clearly, Judge, leaving a gun in a play area for kids is likely to cause serious physical harm, because it did in this case. The victim shot himself, but he could have just as easily shot one of his brother or sister who were up there as well. And those are the evidence that supports these charges. A lot of it is based on Ms. Kegler's excited utterance and the defendant's own statements, as well as what we see in the home. And I would say that understanding that we are at a probable cause standard here, Judge, which is significantly lower than what I would have to prove at trial, with the evidence that's been admitted, which is this court's job to determine or to evaluate the evidence that's been admitted, I would ask the court to bind over as charged. Thank you.
Thank you. So today is a probable cause hearing. This is not a trial. It's a probable cause hearing. Many people talk about how low the standard is and they don't like that standard. But that is the standard here. The standard is not beyond a reasonable doubt. It is probable cause. And as I look at each and every count and cross-reference that with the testimony that has been elicited from the various witnesses, as well as the exhibits that have been admitted, 1 through 9, and the stipulation, a couple stipulations, this court has to make a determination. And as I go through each one of those counts with a fine-tooth comb, I'm satisfied that there's a question of fact, including count 1. There's a question of fact here that needs to be determined by the fact finder. Probable cause is a term of art that we in the legal community use often, and it's not easily understood by those that are trying to understand why they're not hearing all of the evidence that they think is necessary. But at this phase, the prosecutor has to clear a certain hurdle. And I'm satisfied that that hurdle has been cleared as it relates to counts 1, count 2, count 3, and count 4. And I'm just wondering, I noticed that in the complainant or victim section that the other two, the siblings of the deceased, are not mentioned. And I was just wondering why that was, or.
That's an oversight, Judge, on I guess, an oversight on my part. I'll take responsibility for that.
If a first amended can be provided to Madam Defense so that that can be perfected, so that there is a clear understanding of what counts 3 and 4 are relating to, that would be, I think, very helpful.
And I would orally move to amend that to now to include Tamara Quelly and Tremaine Quelly.
Okay. Again, a first amended, I think, is going to be the most official way to do it, and we are making note of that today, that those names would be added to the complainants list, if you will. The matter is going to be bound over to the circuit court. Now, when it gets bound over is when the burden of proof dramatically changes. The burden of proof is going to shift from probable cause to beyond a reasonable doubt. And I'm certain that your attorney is going to hold the prosecution to that much elevated standard of proof. But as for now, with the circumstantial evidence that has been provided, coupled with the testimony and the stipulations and the exhibits, this court is satisfied that the probable cause standard has been met. I'm going to bind over as charged. The arraignment on information date is going to be August 27th at 9 a.m. Is there anything further?
Not for the people, Judge. Thank you.
Just, for clarification, the witness detainer will be thrown out.
I am canceling that. Thank you for reminding me of that. I'm going to cancel the witness detainer.
Certainly, Judge, I was just speaking with my OIC about that, and I was going to ask for it to be quashed or whatever the court does to cancel that. I told the OIC that he needs to remove it from lien today, and to tell people, whoever's looking for her, to stop looking for her.
I'm going to prepare as a written order. Would that be the best way to do it?
Normally I get something from the prosecutor, but.
Oh, can you provide us with something? That would be great.
Yeah, absolutely, Judge.
And we've got, if you want to do it right now, we do have blank order forms. If you want to prepare a proposed order, should it be to?
Oh, you know what? No, it's in the orders that I have it.
Oh, perfect.
Yeah,
Thank you.
usually it's like a package, so you should already have it.
Okay, and with that being said, again, the witness detainer will be canceled. The arraignment on information date is, again, August 27th at 9 a.m.
Well, have a good day. I'm glad to be
Thank you. You too. Have a good weekend.
Is there anybody else today?
Ms. Cat?